May it please your lordship. Also, I beg to mention item 34 and 35 also.
32.
34 and 35. Here we are respond number 4, your lordship.
Hmm.
The affidavit in opposition is ready, but we have sent it to Bombay for signature. I pray for 2 weeks time. I have informed the petitioner.
Okay, you are for response number?
Respond number 4, but
Hmm.
my name is also not reflected. R. Sharma.
Okay.
Yeah, on behalf of respondent 120, I have also send the affidavit for waiting. I need some.
Your affidavit also under preparation. Mr. MS M. Mormon, learned junior government advocate Assam for the response number 1, 2, and 3.
Shall counsel.
Okay. Learned counsel for the response number 1, 2, and 3. In 35. In 35. And Mr. R. Sharma, learned counsel for the response number
1 and 4
4 in 35.
in both the.
Okay. Response number 4 in both there, 34, 35. I have submitted that the counter affidavit on behalf of the respondents represented by them are under preparation, and the same will be filed
2 weeks.
in 2 weeks' time. Full stop. It has been submitted by them that consent has been taken from the learned counsel for the petitioner side to make the prayer. Full stop. The prayers made by Ms. Bormon and Mr. Sharma are allowed release the case after 2 weeks to enable the respondents, aforementioned respondents, to file their counter affidavits.
Obliged.
May it please, my lord. Prayer for listing of a unlisted motion matter, my lord. Matter pertains to eviction, my lord. We may be evicted today, my lord. As per the impugned order.
Okay.
Highly obliged.
May I please, Lordship, item 32 and 33. Actually, Lordship, this matter relating to GST. Earlier, state was taking care of that matter, but during hearing, it was revealed that some notification of the central government has been changed. So, Lordship, I required some time to address on this issue. I have taken consent from the
No,
senior counsel, Mr. Saraf.
Okay. Mr. S.C. Kyle, learned training counsel GST, has sought for listing of these cases
After 2 weeks.
after 2 weeks. It is submitted that consent has been taken from the learned counsel for the petitioners and other respondents to make their prayers. In view of the above, let the case be listed. The prayer made by so and so is allowed, and the cases be listed after 2 weeks.
Interim may be continued, my lord.
The interim order, if any, shall continue till the next listing.
But I beg to mention item.
You are for the
I
petitioner,
am for the petitioner, my lord.
Mr. So and so, Mr.
B. Sharma.
B. Sharma, learned counsel for the petitioner, is present and has submitted that the petition side has no objection to a said prayer. Interim order.
My lord, item number 39, I would like to beg to mention. my lord.
39. Yes.
Learned counsel is for the respondent. We have taken the consent. My lord, we need 4 weeks time to file the affidavit in opposition. Recently, affidavit in opposition was filed. We need time to file the affidavit in reply.
You need how much time?
4 weeks time, my lord.
Mr. B.
B. Sharma.
Sharma, learned counsel for the petitioner, has paid for and is granted
4 weeks time, my lord.
4 weeks time to file an affidavit in reply to the affidavit in opposition filed by the
GST.
respondent GST
Yes.
authorities. Release the
Interim,
case
my
after 4 weeks.
Interim is there, my lord.
The interim order.
May please the lordship, my lord, I beg to mention item number 21, my lord. In this matter, my lord, in terms of the order dated passed by the 12/9/2024 by this honorable court, a fresh inquiry committee has been constituted to make a fresh inquiry into the matter, my lord. So I have taken consent of the other side, my lord, to conduct a fresh inquiry. Some time is required, my lord. Already the committee has been constituted, my lord.
What is this case?
Order dated 12/9/2024, my lord.
In view of section so and so.
Here, Lordship, I am appearing on behalf of the amicus.
So a fresh inquiry committee has been constituted, but it needs some time.
I don't know what is the matter about. We'll take a relevant time.
Yes, my lord. Obliged.
May I please, Your Lordship? Lordship, I beg to mention a listing for an unlisted matter today. The urgency is that I had been allotted a wedding hall by the Panchayat there for 25 years with a clause that it should be renewed after 11 months. Since August, they have been saying that they will renew. I had already taken advance. On 11, there is a marriage to be conducted. Now they are saying just last week, they said that no, you cannot conduct the marriage and all. That is the problem. Now that all these things are, the renewal clause is there. They are not renewing it also. They are not saying why they are not renewing. So maybe listed today because 11th is the marriage because there is the hall has been booked. Everything has been booked.
Okay.
Deeply obliged.
May it please your lordship, I beg to mention item number 53 of today's list, lordship. Lordship, in this matter, we have filed the affidavits on 5th of this month, lordship. It's not on record, lordship.
53.
53.
Yes, what do you want?
I may be allowed to bring on record,
Huh?
lordship. Affidavits we have filed, lordship.
May it please your lordship, I beg to mention orders item 58, my lord.
Item
58.
58. Yes.
In this case, we have to file our affidavit, so 4 weeks time may be granted to do the.
My lord, I am for the petitioner. I have just had a talk with the senior counsel appearing for response number 6 on whom behalf the parents meet. He has agreed to a date 29th November. Can this matter be fixed on 29? There is urgency in this matter. My lord.
Okay.
I am for the petition.
Okay. Mr. MSS Musari, learned counsel for the response number 6 has made a prayer for adjournment. Mr. D. Chakravarti, learned counsel for the petitioner is present and full stop. As sought for by the learned counsel for the parties, list the case on so and so date.
29th of November. Deeply obliged.
Obliged.
May I please, your lordship? With due consent of other side, I beg to mention item number 1 and 54.
One by one, 1 and 50. One will wait when the matter is called. 54?
54, with due consent of other side. My senior A Vishwas is out of station. Only the matter may be adjourned for a
Your name, please.
A Banerjee.
Mr. A. Banerjee. The learned counsel representing Mr. A. Vishwas 54 has made a prayer for adjournment. It is submitted that the prayer for adjournment is made with the consent of the learned counsel for the other sides. When you want 54?
After 2 weeks, lord.
Okay,
Maybe next
as straightforward, leave the case after 2 weeks. May date to be fixed by the office.
Obliged.
May I please, I beg to mention item 27. I have taken consent from the other side and yesterday we have submitted adjournment slip.
Okay.
I'm for petition.
Mr. H. Chetri, learned counsel for the petitioner, has made a prayer for adjournment. It is a mention memo to that effect has already been circulated yesterday, indicating consent of the learned counsel for the other sides. As straightforward, is the case after?
After 1 week.
Now 1 week, it will be fixed by the office.
May I please, lordship?
And similar prayer also in item number 41.
41.
One,
Same.
same. Obliged.
Lordship, this admission matter was posted on 17/7/2024. And other side sought for 1 week time. And thereafter not listed.
Give it to the court master, he'll fix.
Lordship, any date may be.
May I speak, lordship? With the consent of the petitioner side, lordship, I beg to mention item number 48, lordship.
40?
48, lordship. Lordship, kindly this matter may come after 2 weeks.
48.
Yes, lord, 48. I am for Kabiama Pulmat Council.
Okay, Mr.
R.S. Ronghang.
R.S. Ronghang,
Wrong.
learned standing counsel KAAC. Come on, for the respondent, number 2 silo. With the consent of the learned counsel for the petitioner, Kama has made a prayer for adjournment of the case for
Lordship, as per last order, lordship, petitioner was supposed to bring instruction, lordship,
for 1 week
after 2 weeks.
after 2 weeks. Full stop. Release the prayer is allowed, release the case after 2 weeks.
Deeply objected.
My lord, in item number 26, one I is there, that may be called for my obliged.
I should be listed, mister,
That is also true.
separately. No. I used to be listed separately.
In that case, my lord, I will wait for my time. Obliged.
Yeah, please, your lordship. With the consent of the petitioner's counsel, lordship, I beg to mention item number 28, lordship. I'm praying for adjournment, lordship, for a week, lordship. Mr. H. Gupta is my lord, I have stated
You are for the petitioner.
for the respondents.
Hmm.
And I'm praying for adjournment as Mr. H. Gupta is out of station, madam.
Your name, please?
My lord, why were we here?
Hmm?
Why were we here?
Why Borhia? Learned counsel. representing Mr. H. Gupta, learned Central Government Council. With consent of the learned counsel for the petitioner has made a prayer for adjournment of the case for 2 weeks. The procedural is the case after 2 weeks.
Yeah, please, Your Lordship. I beg to mention item number 31. Lordship, in this matter, we are newly engaged counsel and we want to file a reply affidavit against the affidavit.
Mr.
Hardware.
So learned counsel has submitted that they have entered appearance for the petitioner recently and has made a prayer for adjournment. It is submitted that you have taken consent.
Other side is government.
No, other side is government, there are council's name who doesn't appear to be government council. Yes, next. No, you make a prayer when the case reach.
May I please, I beg to mention for listing, my lord, for admission matter, my lord.
What is the subject matter?
My lord, regarding victim compensation matter, my lord. 13, my lord.
Don't choose a date.
May I please, Your Lordship? So with the consent of the others, I beg to mention item number 30. The matter may kindly be adjourned for the day. If the reason is out.
You are for whom?
For the petitioner.
Your name?
A. Ahmed.
On the prayer of Mr. A. Ahmed, learned counsel for the petitioner, the case stands adjourned for 2 weeks.
I am
It is submitted that MS Borua? Ms. S. Borua, learned Central Government Council. For the respondents is present and has submitted that she has no objection to the prayer.
For motion item 1. On last date, your lordship has, my lord, called for the instruction.
Who made a prayer for adjournment?
My lord,
Yes, anything.
My lord, they are in fact seeking 2 weeks time, my lord.
Mr. N. Sarkar, learned counsel for the petitioner, has made a prayer for adjournment. First of MS M. Bormon, learned junior government advocate. Assam. This kind of excuse is not welcome.
With this instruction by placing it.
Not take notice of this. Has submitted that she has received instruction to make a prayer for adjournment. For 2 weeks in order to enable the circle officer dispute revenue circle to place the instructions. As ordered, as directed by the order dated 25/10/2024. First of, in view of the accommodation sought for and by the learned counsel for the parties, lays the case on so and so after 2 weeks. Side your agreement.
Obliged.
Item number 2.
Madam, this is contempt violation of order dated 19/4/2024. Lordship may see at page 20, my lord.
20.
20, my lord. The operative portion of the order, my lord. Lordship may read.
Accordingly, in the dispose of the incident, the direction to respond number so and so to consider the reposition of the petition.
Although. this-
Yes, MS Hazurika, can you take instruction? Only to consider. Consider the representation by the commissioner and secretary. Take some instruction, consider, not positive, not negative,
But of course.
but application of mine.
But there is an observation, Lordship may say para 20, my lord, page 25.
To complete the exercise.
But this long pending, my lord.
Yes,
Yes.
to complete the exercise.
Yes.
So far as decision is concerned, it is up to him. Discretion is up to him.
I'll leave it to lord. Note.
Heard Mr. J. Roy, learned senior counsel, assisted by Mr. Judge J. Roy. Learning counsel for the petitioner, full stop. This contemplation is filed alleging non-compliance of the direction made in an order dated 19/4/2024, passed in a petition, WBC number 4962/2022. Full stop. The petition was referred regarding non-disbursement of compensation amount. For lands acquired by the government of Assam under the Assam State Acquisition of Zamindari Act 1951. Full stop. It transpires that the litigation reached up to the Honorable Supreme Court when the state government approached the Honorable Supreme Court against the judgment and order dated 16/12/1976. Passed in, sorry, passed, against the judgment and order dated 23/1/1996. Passed by this Honorable Court, passed by this court. And Honorable Supreme Court has dismissed the appeal. Post up. But under repetition, WBC number so and so was disposed of with a direction to the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department to consider the representation of the petitioner dated 28/2/2022 as per the stipulation of the order dated 20/01/2014 of the Revenue within bracket Reforms and Disaster Management Department on its merits and in accordance with law within a period of 2 months from the date of receipt of a certified copy of the order dated 19/4/2024. Post up. It is the case of the petitioner that copy of the order dated 19/4/2024 has been served upon the respondent number 1 on 26/4/2024. Post up. And the same has been duly acknowledged by his office. Post up. It is in the above backdrop, this contempt petition has been filed, full stop. Has been filed alleging non-compliance. Full stop. MS Z. Hazurika, Standing Counsel, Revenue within bracket Reforms and Disaster Management Department is asked to obtain instruction as to whether instruction about the status of the representation dated 28/2/2022. Full stop.
Anything,
When? First, I asking without issuing notice.
Yes. No, what Mr. DC is not a, well, there is no direction to the DC,
Yes.
but we have implemented DC because all the correspondence we made the DC also because he is the disbursing authority.
Okay, we are asking him to obtain instruction.
But I must point out.
When we'll issue notice, then
No, I just want to point out that because this is not, there is no direction to the DC.
yes,
but
that is why.
Yes.
First week of December.
December, okay, Miss is shall obtain instruction as regards the present status of the representation is so and so, huh? Secondly, Mr. J. Roy and counsel for the petitioner shall furnish a copy of the writ petition of contempt petition along with annexer to MS G. Hazarika during the course of the day.
Yes.
Course of, lays the case on first 4th of December. The name of MSG Hazurika, Land Standing Council Revenue and Disaster Management Department be reflected in the respondent side in the cause list.
Oblige.
Item number 3.
In the earlier occasion, my lord, in instruction was called for.
Yes, instruction received lordship. You have to receive the instruction. There was an accident lordship, that is true, and FIR was filed and no trace of unknown negligent person. Otherwise, there was an accident. Subsequently, the office of the additional deputy commissioner Walpura has sent all the documents to the deputy commissioner for processing laws.
Processing. We can dispose of. Oh, actually, yes. Let them complete the inquiry.
The inquiry is completed, but they have to process. Deputy commissioner
Heard Mr. M. Hussain, Land Counsel for the petitioner.
I've got 3 to 7 laws.
G. Hazurika, Standing Council Revenue and Disaster Management Department, Relief and Rehabilitation Liquidity. For response number 1, Mr. Gugoi is there? Or any finance? Mr. B. Gugoi, Land Standing Council Finance Department. For the response number 2, Mr. N. Gusami, Land Junior Government Advocate Assam. For the response number 3 to 7. The petitioner has projected that she is the wife of one late Saidur Rahman. You have said Raham, paragraph 2.
Oh, sorry, Rahman. In the FIR, my lord, Saidur Rahman.
The petitioner has further stated that her husband, Saidur Rahman, sustained injuries in a road traffic accident, which occurred on the National Highway 37 on 14 to 2020. Full stop. Though from the place of the accident, Saidur Rahman was taken to the Jorhat Medical College and Hospital by a 108 ambulance for treatment. No, they are from the place of full stop. But while undergoing the treatment at the Jorhat Medical College and Hospital, Saidur Rahman succumbed to his injuries on 15 to 2020. Full stop. In connection with the accident, an FIR was lodged, and the same said FIR was registered as Jorhat Police Station case number 397/2020 under sections 279, 304 A, IPC. Full stop. After completing investigation into the case, an investigating officer had submitted a final report. Right, final report number 1592/2020 on 30/11/2020 reporting that despite investigation, the culprit could not be traced out. Full stop. After the date of her husband, the petitioner stated to have filed a representation before the District Commissioner Jorhat seeking disbursement of ex gratia grant in terms of the policy formulated by the state government and notified by a notification dated 15/11/2014 of the Revenue and Disaster Management Department, Government of Assam. Full stop. In the state notification dated 15/11/2024, provision for an ex gratia grant to the next of kin of a person killed due to accident in public places or in public carriers. Provision for an ex gratia grant of rupees 2 lakh. To so and so has been provided for.
My lord,
Full stop.
in this regards, my lord, I have want to submit, my lord, in clause 3. Page 15, my lord, notification has provided ex gratia to the another person killed due to accident in public place or in public carriers. Other than killed by extremist, terrorist, miscreant, and due to firing of security forces, my lord.
Yes.
But in this case, my lord, what have happened, my lord? The unknown culprit, my lord, knocked down the deceased and fled away, my lord. And accordingly, the police has submitted a final report, my lord, stating that no clue is found about the culprit, my lord.
So,
So, my lord, so we filed a representation, my lord, under clause.
then
4.
will issue notice. If you are claiming something more than this is your notification you have claimed.
Yes, my lord. We claimed under clause 1, my lord.
Then will issue notice. Then no purpose. These are terrorists, miscreants, extremists. These are defined.
Yes.
No clue is found.
Yes, my lord. Dispose
Remain.
of.
You remain like that.
Okay, my lord. Dispose of.
You find out the terrorist will
Yes.
give you ground.
Okay, my
You
lord.
find a terrorist. Terrorist is defined in the UAPA Act.
Yes, but miscreants is there, my lord,
Miscreants will not do anything.
because,
Untraceable.
yes,
Otherwise, you challenge this final report.
no,
Challenge the final report.
my lord, dispose of it, my lord.
Otherwise, this is difficult.
Yes, my lord.
Any postmortem report?
No, my lord, we have not annexed the postmortem report, my lord.
So the petitioner has also submitted a next of kin certificate issued by the Office of the District Commissioner, Gwalpara, on 13/5/2024 to substantiate the fact that she is one of the next of kins of the deceased, Saidur Rahman, post of para. When the petition was listed on 12/6/2024, the learned counsel for the respondents were asked to obtain instructions in the matter, full stop. Para. Today, Mr. Kusami, a junior government advocate, Assam, has submitted that he has received Para's comments and placed those Para's comments before the court for perusal, full stop. Para.
Below the paragraph.
Okay. From the Para's comments, it is noticed that the additional deputy commissioner Gwalpara, after inquiry as regards the next of kin of the deceased, late Saidur Rahman, has already submitted a report that the petitioner is one of the next of kins of the deceased, and the deceased at the time of his death, left behind one son and 3 daughters. Full stop. The death certificate issued by the Register of Birth and Death has also been collected during the inquiry. Apart from the medical certificate of cause of death from the Guwahati Medical College or Jorhat
Jorhat, my lord.
Medical College and Hospital. Full stop. Para. At what stage it is there, Mr.? Any idea?
No.
Okay. Miss Hajorika, Mr. Gogoi and Mr. Goswami are not in disagreement to the fact that in this petition, the petition has claimed that the alleged road traffic accident in question had occurred subsequent to 15/11/2014. Post up. It is submitted by so-and-so in addition that before placing the matter before the commission so-and-so, 8, 9, 10. How much? 3 months? Gwalpara.
No,
District
my lord.
Commission is Gwalpara.
No, Jorhat.
Jorhat.
Jorhat will take.
Jorhat.
Okay.
The SP report is also there. The
SP report.
The paragraphs.
As per the instruction placed by the Superintendent of Police, Jorhat, the fact that the deceased expired succumbing to his injuries in an accident. In a road traffic accident. By a scooter without a number plate. It has been reported, right? As far as in the instruction place, so it has been reported that the accident had occurred and the deceased succumbed to his injuries. And in the said accident, a scooter without a number plate was involved. And no trace, since no trace of the accused could be found, the case, Jorhat Police Station case number 397/2020 was returned in a final report, final report number 1592/2020. The instructions placed by Mr. Goswami are kept with the case record.
Item 4. The matter relating to income tax department. He paid for installment.
Yes, something installment.
That's the officer was on leave. He's joining today. So I pray that matter may be taken on next Tuesday. So I can.
Let it be a next Wednesday. Okay, RS Mr. Learned Counsel for the petition and Mr. S.C. Kyle, Learned Standing Counsel Income Tax for all the respondents are present. First of Mr. Kyle has submitted that has sought for by Mr. Kyle. Let the case be listed on Wednesday. Miss M. Bormon, Learned Counsel representing SKMD, Learned Central Government Council for respondent number 1. লিখি দিব লগত।
Item 5.
My prayer, it may be taken at 2 p.m. I have some at 2 p.m. can you know, at 2 p.m.
Only one line, if your lordship, that will be 2 o'clock. But one line, if I want to show only because so this is third round of litigation. First round is over. Second round, your lordship will get it. Page 30, annexure 8, page 29, operating portion is Miller. I'll let it start from 30 Miller. Here only, it's a very short order Miller. Married. Lordship. Affidavit is filed by color, this one, so and so, so and so, so and so.
Read.
And
Third round will be over today.
no, our means.
I have seen.
Court. This particular word is court.
I have seen competent court
Competent court.
and plus disputed questions.
Disputed question.
I have seen.
He has approached to
Third round would be over today.
Today is over. Now itself it is over.
At 2 or now, same thing.
My 2 p.m. your lordship.
2, okay. You want to delay it?
Some hours.
It should not come at 2 o'clock morning time.
Item 6.
May please your lordship.
Saidul Islam. Yes.
My lord, 3 brothers were the owner of the land in question, my lord. Out of 3 brothers, my lord, 2 brothers died. 1 brother living. So that land mutated in the name of deceased brother and the 1 brother is living. Now, my lord, land has been acquired by the government. And in the beneficiary list, my lord, our father's share we inherited, but our name is dropped. That is the case, my lord. They have get the compensation. Compensation is given to 2 brothers. 1 brother directly and
So what is the prayer here?
here prayer is this, my lord, that beneficiary list
Initially in the beneficiary list, your name was not there.
not there. So
Then money was already,
Disbursed.
award was passed.
past
And the amount was disbursed.
disbursed also.
Then what is left for this court?
My lord,
You establish your claim in that particular land
yes,
by leading evidence.
my lord.
And
No, my lord. your
Mr.
lordship.
Mr. Sheikh, money has been disbursed when?
My lord, recently it is not far back, my lord.
Then who will recover?
My lord, deputy commissioner will recover, my lord.
Why we should enter into that?
My
You
lord,
go to the civil court.
No, my lord, why civil court? My question is this. my lord.
Okay, you are.
My lord, my argument is this. Land has been acquired. That record is there, my lord.
We are not here for recovery of your money.
No, my lord,
And we are not.
Not
Be-
recovery, my lord.
Mr. When the land was acquired,
My lord,
you kept silent.
my lord. No, my lord. I did not keep silent because it is a notification.
No, where you have filed a complaint
My lord,
to make it a reference to the.
my lord, that is lacking, my lord. I have not filed any complaint. Complaint may file, my lord. That
No,
is
we'll not enter in this. I have seen it.
Your lordship, your please to the
Appropriate competent court.
land has been taken away. No, my lord, why civil court? My
Okay, you argue. Why not
No, my
civil
lord,
court?
yes,
You argue
my
on what?
lord, land has been taken. 3 brothers, your lordship will see the Jumamundi.
We are not here.
My lord,
to
no, my lord, deputy.
When the amount is disbursed,
No, my lord, deputy commissioner disbursed ordered arbitrarily, my lord. And
arbitrary,
illegally.
but we don't know. Your
deputy-
name was not in the list of
My lord, my humble
beneficiaries.
submission before your lordship, when deputy commissioner is involved, my lord, circle officer involved, My land has been taken away. My share is not given to somebody else, my lord. It is not a case that deputy commissioner should disburse the amount to the proper beneficiaries, my lord. In the beneficiary list, why we were dropped, my lord? That is my humble submission before your lordship. Deputy commissioner involved, your lordship will be pleased to see the notification.
Submission. Mr. Sheikh, learned counsel for the petitioner, has submitted that. I'll record every submission.
No, my lord, your lordship.
No,
record. Please to issue notice to the deputy commissioner.
Discretion is mine.
My lord.
Discretion is mine. You make your submission.
My lord, my humble submission before your lordship. My land has been taken away.
The
But benefit of
petitioner's
the-
land has been taken away
But benefit of the land is
by
not given
way
to me.
of an acquisition process, but no compensation amount has been paid to the petitioner.
Share of compensation.
Share of compensation amount has been paid to the petitioner.
Yes, ma'am. So, my lord, now my humble
He has submitted that.
Prayer is this, my lord. Share of money may be
action
given to me.
of the
Beneficiary list may be.
of the district commissioner, another official respondents in the process of acquisition and disbursement of the compensation is questionable. Full stop. Anything more?
And my lord, I prayed for modification of the impugned list of beneficiaries. I prayed for,
The petitioner had requested the official respondents to furnish him a copy of the list of beneficiaries, but the same was not provided to him deliberately. Anything more?
no, my lord, now my prayer is this, that this impugned list of beneficiaries may be modified.
Your entire prayer will be quoted.
Yes, my lord.
Your entire prayer will be quoted.
Yes, my lord.
Heard. Mr. M.S. learned counsel for the petition. Yes. Z. Hazarika, learned standing counsel, Revenue and Disaster Management Department. And Mr. N. Goswami, learned junior government advocate for the respondent number 2 and 3. Full stop. Having regard to the petitioner has stated that he is father, Amiruddin, within brackets, since deceased, possessed a plot of land a parcel of land, measuring 3 kathas, 15 lessas, in total, with his 2 brothers, Azimuddin Ahmed, within brackets, since deceased, and Atwar Rahman, within bracket, who has been impleaded as party respondent number 5 in this writ petition. The legal representatives of Azimuddin Ahmed, since deceased, are impleaded in this petition as party respondent number 4. Para. The petitioner has stated that Amiruddin died living the following years. Table page pivot. Para. It has been stated that after date of Amiruddin, the names of his heirs stood recorded in the revenue records pertaining to the parcel of land measuring 3 kotha, 15 lessas, covered by dag number 876 and annual pata number 64, situated at village Kandulia, Moja Titapani, Kolgase Revenue Circle, District Borpeta. District Borpeta or District Bongaigaon, within bracket, earlier District Borpeta. Post stop. It is a further case of the petitioner that out of subject plot, out of the subject plot, an area of land measuring 1 katha, 5 lessa, is under possession of the petitioner and his siblings. Question. Para. Subject land A লিখি দিব। Next one. For short. The government of Assam initiated a process of acquisition of land wide LA case number 9 stroke 2011-2012 for improvement and strengthening of state highway number 2 in the for acquiring parcels of land measuring more or less 16 bighas, 1 lessas in village Kandulia. First stop. And in the said process of acquisition, the area of land fallen under subject plot A got included. Full stop. The state respondents prepared a list of beneficiaries for the purpose of payment of compensation for the lands so acquired avoid the proceedings in LA case number 9 stroke 2011-2012. Including the subject plot A. Full stop. The acquisition process, sorry, the construction of widening and strengthening, the improvement and strengthening of state highway number 2 included double laning of existing carriageway under the Assam State Road Project, ASRP. There's portion, page 25 ত আছে, চাই লব ভিতৰত, from Langla to Borpeta town. Post para. In the impugned list of beneficiaries, the name of the petitioner and other legal heirs of late Amiruddin were not enlisted. Post. But in the said list of beneficiaries for receiving compensation in connection with subject plot A land, in connection with the land falling under subject plot A, the names of Azimuddin, since disease, and Atwar Rahman were included as beneficiaries. Full stop. After inclusion of their name, the amount of compensation assessed against subject plot A had already been disbursed.
In that, my lord, I am not sure that what is.
Your statement on oath, paragraph 9.
My lord.
Statement on oath.
Then all right.
Read your statement.
Yes, ma'am. Then all right.
The entire compensation amount assessed against in connection with the area of land under subject plot A has already been disbursed to the said to respondents. Full stop. आप जो submission के लिखिबो.
My lord,
to
I
record
have
kori.
filed representation, my lord. That is at page 27. Page,
Mr. Sheikh has further submitted that
page 30.
he also submitted, the
35.
petitioner also submitted a representation before the respondent number 2 on 7/11/2022 to verify the impugned list of beneficiaries for inclusion of the name of the petitioner. First, para. This writ petition is preferred, seeking the following reliefs, firstly, to modify the impugned list of beneficiaries of in respect of subject plot A by inserting the name of the petitioner and his siblings. Secondly, to direct the respondent number 4A to 4G, who are the legal representatives,
4G and respondent number 5, my lord.
legal representatives of Azimuddin Ahmed, since deceased, and the respondent of 5
Yes.
to return the share of compensation already received by them in connection with acquisition of land, acquisition of the area of land under subject plot A, and thirdly to direct the respondent number 2 to pay the said compensation to the petitioner and his siblings after recovering it from the respondent number 4A to 4, respondent number 4G, and the respondent number 5. Full stop. Para. From the documents in the case papers, comma, the from the case papers, comma, it transfers that the land acquisition proceeding was initiated by the LA case number 9/2011-2012. And the notification under Section 4 of the Land Acquisition Act 1894 was published by notification number RLA.76/2012/65 dated 25/7/2012. Full stop. Subsequent thereto, comma, the declaration under Section 6 of the Land Acquisition Act was published by a notification number RLA.76/2012/66 dated 30/05/2013. Full stop. In both the notifications published under Section 4 and Section 6, comma, the parcels of land which were sought, which were acquired later on, was described, were described. Sorry, details of the parcels of land. Full stop. From the later dated RLA page 27, 76/2012/131, comma, and a supplementary award amounting to 94,71,237 was approved by the government of Assam in the Revenue and Disaster Management within bracket LR department in 2020. Indicating therein, most of thus it is evident that the award in that connection was passed earlier to the supplementary award. Full stop. It is an admitted position that the name of the petitioner, neither the name of the petitioner nor the name of the petitioner's siblings as a legal heir, as a legal representative of Amiruddin, was included in the list of beneficiaries.
Date may be mentioned, my lord.
Which date?
Beneficiary list, my lord.
When, where it is?
Page 34.
Page 30.
Below, my lord, additional deputy commissioner, 5/9/2020.
5/9/2020. Full stop.
1894.
Land acquisition.
My lord, may I submit one thing, my lord? That Land Acquisition Act, earlier Land Acquisition Act will apply, or this Fair Compensation Act will apply, my lord. That is the theory. Under which?
We are looking into the period when 4 and 6 were notified.
My lord. My lord, it is of 22.
4 and
Act is
I know,
2013.
I know.
My lord,
But
Act-
4 and 6 were published when that 2013 did not come.
in that earlier act will come. Okay.
If the petitioner was a person interested in respect of subject A land, he could have preferred an objection at the relevant time when the notification under section 4 or the declaration under section 6 were published, which were published as far back as in the year 2012 and 2013 respectively. First of the petitioner is silent as to when the award was passed, though it is mentioned in the petition that the supplementary award was passed in the year, the state government. So the government was some in the Revenue and Disaster Management Department had approved and supplementary award in the year 2020. First of. Well, it has also emerged that the entire compensation amount assessed against subject A land, subject plot A, has already been disbursed in favor of respondent number 4A to 4G. When he died, your father died?
My father died, Ajmuddin also died, my lord. Only.
No, when your father died?
My lord, that
That you don't know.
My lord. That is, I have.
Petitioner does not know when his father died.
Actually, my lord, your lordship will turn to page 16. Page 16, right hand column. Uttaraধিকার পুত্রে আমিরুদ্দিন ও সলত সাইদুল Islam. So it was the
as
order of
already first of
2015.
In order to first of the aforesaid facts and circumstances would give rise to a number of disputed questions of fact. First of, it is for the petitioner to first establish that he is a person interested in respect of subject plot A land. First of, and it is after establishing such claim, he could stake a claim in the list of for consideration of his case as a beneficiary to receive compensation in connection with subject plot A. First of. In the process of disbursement of compensation, the acquiring authority disburses the compensation amount after a receipt of necessary documents and including indemnity bonds from the recipient of the compensation amounts. Full stop. If the petitioner is able to establish his bona fide claim in respect of subject A plot land, then only, the acquiring authority, like the acquiring authority, can proceed with against the recipients of the compensation amounts in favor of whom the land compensation amounts have already been disbursed on the strength of the indemnity bonds, etc., submitted by those recipients. Full stop. A writ proceeding in such view of the matter, a writ proceeding before under Article 226 of the Constitution of India is not an appropriate proceeding for the writ petitioner to pursue, and as such, this writ petition instead of not proper proceeding, and the petitioner should approach the competent court of law to decide
No, my lord, here-
for adjudication of the disputed questions of law, facts and the facts involved.
Here, my lord, I may be excused. I'm interfering in your lordship's order. I have filed a representation before the deputy commissioner, my lord. My lord, deputy commissioner disbursed the amount. And on the basis of land records, let my petition be inquired into
Yes.
the deputy commissioner.
Yes.
If the deputy commissioner finds that exactly it may be behind the back of the deputy commissioner also, my lord, I humbly submit. And somebody has done it.
No, you have Malafide, you have already submitted Malafide.
No, my lord.
Now don't say about bona fide now.
No, my lord, not Malafide, I am not.
No, I have recorded already.
No, my lord, not Malafide. I'm submitting, my lord. Your lordship will consider. I'm submitting that it may so happen. Deputy commissioner is the higher authority. So my lord, in the grass level, my lord, this Mondol and the SDC and other persons, my lord. Now what happened, my lord? If the deputy commissioner finds that I have a share in the land and indemnity bond is there, already your lordship mentioned. Let the deputy commissioner inquire into the matter. If some injustice has been done to us, we are landholder. And regarding this,
No,
my lord,
Mr. After decision, it is deputy commissioner is powerless.
no, my lord. And on
When no, Mr.
Man.
Soed Mokul Ali to devotion, when your name is not included
my lord,
in the list of beneficiaries,
my lord.
and it was far back, already the amount is disbursed.
No, amount is disbursed. As your lordship mentioned that indemnity bond is there. Time is not over. Money they have taken, not in the deputy commissioner's office. It is taken by the private respondents. Let the deputy commissioner inquire into the matter. We have filed a representation, inquire into the matter. If it is found, yes, there is some mistake, then relief can be granted to us. The deputy commissioner do, my lord. It is not that your lordship will direct that disburse the amount to us. That part can be done possibly, my lord. I humbly submit before your lordship. Let the deputy commissioner inquire.
I'll do what I do that
Deputy commissioner inquire.
I'll not dispose of this petition. You file in face with all the documents. We can say. I'll not. I generally don't dispose petition to consider representation. Normally, very rare case. This court, if
Okay, my lord, as your lordship decide.
yes, Mr. Goswami,
Fresh representation I will file.
we are not adjudicating all these disputed
My lord.
questions.
With all documents, my lord, I will file representation.
Post of
only
competent
thing-
court of law.
Another prayer will be.
For
before your
adjudication of the disputed questions, such disputed questions of fact, post of, in such view of the matter, the instant repetition is not entertained. Post of para. The petition, at this stage, Mr. Sheikh Learned Counsel for the petitioner has submitted that the petitioner be granted an opportunity to prefer a representation, fresh representation, along with the supporting documents as regards his claim as a person interested in respect of subject A land before the jurisdictional deputy commissioner, that is Commander Deputy District Commissioner Borpeta. Post of in view of such prayer, the liberty sense the petitioner may prefer a representation. Prefer a representation before the jurisdictional deputy commissioner, highlighting his grievances
District.
as regards.
Nowadays, district commissioner.
Sorry, before the jurisdictional district commissioner, that is district commissioner so and so, highlighting his grievances about non-inclusion of his name and his siblings in the list of beneficiaries in connection with subject A land.
My lord, may I pray that if representation filed, my lord, that may be disposed of in a certain time.
Otherwise, I'll direct you to competent court of civil law.
Oblige, my lord. Only thing is this, my lord, in the course of dictation, my lord, one thing has been said that I have not raised any objection regarding this objection.
No.
My lord.
I have not raised, okay, the
Regarding-
petitioner is silent about raising any objection in respect of notification 4 and notification declaration 6.
No, my lord, here.
Silent in the petition.
My lord, yes, all right, my lord, it is silent. My lord, thing is this, my lord, nobody raised objection. Respondent number 5, 4A and 4C, they did not raise objection.
Why they will raise objection? They are getting money. Why they will
No, my lord,
object?
No. Thing is this, my lord, when land is
People are
acquired.
not that honest nowadays.
My lord, further I am pointing out to your lordship, I am satisfied that actually nobody raised objection. Let the land take, but compensation should be given. So question of objection does not arise. My lord. Did not raise objection. Objection was invited. We did not raise objection. That part is clear, my lord. That may
At the
not be
stage
in
of
the order, my lord.
4, there is 5A.
My lord.
After 6, there is section 9.
My lord.
And then after section 11. That is why I have said.
That is there, my lord. But regarding this objection, my lord.
Next.
That part may be deleted from this, my lord.
Okay, I'll consider.
My lord. Oblige, your lordship.
Now in the middle after dictation, I cannot,
Yes, my lord.
when it is not yet.
Just I have pointed out, your lordship.
Yes, Topon Haldar.
That order of your lordship will perhaps cover that when the 731 notice has not been issued. Instead of that, somebody.
I have given the copy, my
The
lord.
only thing, my lord, let it be on Wednesday. Let me have a short instruction from
Okay.
the department. Today itself. If they have not issued, then it will be.
Okay, your objection was taken care of there. 26(3), I think.
Yes.
Something you objected.
Yes, sir.
So I
Yeah,
did
yeah.
not say. Okay. Mr. Gupta?
On Wednesday.
Okay.
Both items.
Heard Mr. A.K. Gupta. Council for the petition is present, as sought for by Mr. Gogoi. B. Gogoi, Learned Standing Council, Finance and Taxation Department. Let the case be listed on Wednesday.
Item 8 is similar, man.
7 and 8.
7 and 8 similar.
Item number 9.
No, please, your lord.
Yes.
And in this case, my lord, the petitioner, husband was allotted a plot of land allotment certificate at page 27, my lord.
Petitioner is Savitri
Yes,
Gwala,
Yes, wife, my lord.
wife of,
Wife
okay,
of
Savitri Gwala.
Yes, wife of Samlal Gwala, my lord. And lordship may kindly come to page 27 is the allotment certificate that has been issued.
27.
Yes, my lord.
27.
Distribution of documents to prove allotment of land acquisition under Assam.
Yamla, who is Yamla?
Samlal
Your
Gwala,
husband.
Husband, my lord.
Huh.
The land acquired as per the Assam Fixation of Ceiling of Landholding Act as detailed in the below mentioned schedule is allotted to you to enjoy possession over the said land as per the terms and conditions mentioned overleaf. So it was
Oh.
issued on 1991.
Which district?
This is a Karimganj, my lord.
Karimganj.
Yes, my lord.
6 bigha.
Yes, 6 bigha was allotted for residential and homestead purpose, my lord.
Mhm.
My lord, pursuant, prior to that, my lord, there was the subdivisional land advisory committee, my lord.
Mm.
Resolution was there. In view of that resolution, my lord, that allotment has been given and this certificate was thereafter issued, my lord.
Mm.
So thereafter, my lord, lordship may kindly come to my lord. The next page is 31, my lord. So since then, my lord, we are enjoying the property, my lord. We have been given certain condition that we should utilize the land for the purpose for which it was given, my lord. So for residential and agricultural purpose, we are enjoying, my lord. We are using it, my lord. Thereafter, my lord, in the year 2015, my lord, there was a government notification, my lord, that has been circulated to all the deceased, my lord, at page 31, my lord. I will read, my lord. That is from Additional Chief Secretary, Government of Assam, to all deceased settlement officers, Karimganj. I will read, my lord, from the original one, page 33, my lord.
Okay, then what is the?
Now, my lord, in this certificate, a periodic patta is to be straightway
Okay.
issued, my lord.
Now what
So
is your
there-
grievance?
So my grievance is, my lord, thereafter, my lord, when I sought information, I was given an information that I am in the pattadar at page 41 may seen, my lord. It's very relevant, my lord. 41, my lord. I will take, my lord, the original one, my lord.
41.
Lordship may see, my lord, this is an application for information, my lord. So if lordship sees, my lord, lordship will find, my lord,
Various conduct in establishment. So acquisition process is going on or what?
No, my lord.
No, first para. 41.
Yes, sir.
Okay. Okay.
41, my lord.
Hmm.
There is an application for information, my lord, regarding the land in question, because in view of that 2015 notification, my lord, it was already made Miadi Patta, my lord. So it has been mentioned, my lord, in the middle column, my lord. Lordship may kindly see, my lord. Dag number mentioned Sreni Potit. That is the area.
Now what is your grievance?
Now, my lord, what has happened, my lord? Recently, my lord, when this letter has been issued to me, my lord, may kindly come to page 44, my lord. With reference subject, I have to directly request you to pursue the mutation of the land in the light of resolution as approved by SDLC meeting on 1991 by this office memo so-and-so in LSC case number and the land policy 2019, particularly prohibiting diversion of agricultural homestead land for industrial and commercial purpose. So now and thereafter, my lord, what has happened? They have hanged one signboard, my lord, in front of my land at page 47, my lord. This is a government land, trespassing is illegal, unauthorized occupation will.
Yes, Mr. Goswami.
My lord, my lord.
Page 42, Lord.
Huh?
Page 42, Lord. Major report from the circle of Lord.
What is report?
My lord, page 42 may seen, my lord.
42.
42, my lord.
Para 3, Lord. So in this regard.
In this regard, Office of the Undersigned would like to draw attention to the fact that the schedule of land mentioned are not mutated in accordance to the
Who
norms.
is Joynaran?
Joynaran and 6 others. Joynaran is another settlement holder, my lord. And I am 3 others means I am included there, my lord.
Okay.
With whom the applicant MKC infrastructure came to lease agreement. And they have mentioned my patta number as well as the, my lord, the dag number. Patta number is also there, my lord, in the previous paragraph, my lord. 338/496.
338.
/496, my lord, the second one, my lord. And thereafter, the patta number is 146, my lord. When they have a patta of a land, my lord, how it can be a government land, my lord?
It is not mutated in the accordance with the norms.
Heart, Mr. Zialom, learned counsel for the petitioner. Yes, Monto and Goswami made out a privacy case.
That was not mutated as per norms.
You were supposed to mutate. You were supposed to mutate. Come to the document of the Revenue Department, page 31. Then come to page 34. You are supposed to mutate. How can they mutate themselves? Going to the, taking out the Sita, do it themselves, no? Hard. And Z. Hazurika, learned standing counsel, Revenue and Disaster Management Department for the respondent number 1. And Mr. N. Goswami, learned junior government advocate Assam for the respondent number 226. Full stop. Para. In this petition, the petitioner stated that the petitioner was the wife of one Shyamlal Gwala, who in bracket since deceased. Full stop. In this petition, it is projected that the Subdivisional Land Advisory Committee, SDLAC, Karimganj district, in its meeting held on 7/1/1991, had approved allotment of a plot of land measuring 6 bighas, wide resolution number 10. Full stop. The subsequent thereto, wide an allotment certificate, the petitioner's husband, Shyamlal Gwala, was allotted a plot of land measuring 6 bighas covered by DAG number 338 in village Maligaon, Potapgarh, Moja Potapgarh district, Karimganj.
Yes, my lord.
Subject dot. Full stop. From the allotment certificate, it transpires that the subject dot was acquired, was taken over under the provisions of the Assam Fixation of Ceiling on Land Holding Soito Act on Sailovo. Allotment certificate 25/10/1991. Full stop. The government of Assam in the Revenue and Disaster Management Department, via its letter dated 21/4/2015, had instructed all the deputy commissioners and settlement officers had conveyed that the state government had decided to issue periodic patta in favor of the eligible allotment certificate holders straight away without issuing annual patta, as per the prevalent practice then. Full stop. Thus, the petitioner, as husband, and subsequently, the petitioner was under the expectation that the periodic patta would be issued in favor of the petitioner as per the policy of the state government. Full stop. The name of the petitioner's husband stood reflected as a pattadar in respect of the subject land in the revenue records. Full stop. The petitioner has approached this court by this writ petition, hesitating that recently, on 17/9/2024, the respondent number?
The respondent number DC, my lord. The respondent number?
Additional Deputy Commissioner.
Additional Deputy Commissioner.
Is a party?
Yes, my lord. It's a party, my lord.
The respondent number?
Respondent number, my lord, 3, my lord.
3. In his impugn letter dated 17/9/2024, has mentioned that the mutation of land . there is requirement of mutation of land. In terms of the resolution number 10, adopted by the SDLAC in its meeting dated 7/1/1991. It has been further informed that the Land Policy 2019 prohibits diversion of agriculture stroke homestead land for industrial and commercial purpose. Full stop. After issuance of the said, it is submitted by Mr. Allotment, counsel for the petitioner, that after issuance of the letter dated 17/9/2024, what does it say?
It's
It
a-
is
it's a
signboard or what is
signboard.
the English name?
Signboard.
Huh?
Signboard in front.
A
of my
signboard in front
The-
of the subject land.
The roadside market.
In front of subject land has been put stating that the subject land is a government land and trespassing is illegal. And unauthorized occupation would attract penal provision. Full stop. Issue notice, the matter would require further consideration. Issue notice, so and so, appear so and so, extra copy, so and so. Full stop. And the petitioner's husband was allotted the subject land pursuant to a resolution dated so and so of the SDLAC, and as per the policy, notified policy of the state government, the periodic patta notified in the year notified by letter dated 21/4/2015, the eligible allotment certificate holders were to be issued periodic patta. Full stop. In such view of the matter, the petitioner has made out a privacy case for interim relief. Full stop. Accordingly, it is provided that there shall not be any kind of eviction process in connection with the subject land till the returnable date.
I may not be disturbed my possession. Ma'am. Yes. Yes, ma'am.
There shall not be eviction.
Yes. Yes.
Any eviction process, I say.
Oblige, madam.
Item 10.
May I please? Lordship, this matter relates to Lordship income tax. Lordship, in this case, Lordship, notice has been issued under section 148 to me. That is for reassessment, Lordship, without there being any assessment. Lordship, as your Lordship very well knows that it's a established principle.
I don't know anything.
Lordship,
Don't say the word very well.
Lordship, it's an established principle of law that without there being an assessment, there cannot be a reassessment. I have been issued a notice of reassessment for my tax liability, Lordship. Lordship, I am basically an exempted unit because my threshold limit is less than, Lordship, the limit which is liable to tax. That is why I have never filed
It
my
appears to
returns.
be, you appear to be negligent
Lordship,
in responding the notices earlier.
Lordship, so far as notice is concerned, Lordship, first notice was given to me on, Lordship may kindly see, on 21/2/2023 by the respondent number 2. Lordship, I asked for 10 days time. Thereafter, Lordship, I appeared before the Lordship, at page 60, I had given the reply. Thereafter, Lordship, I had appeared before the person and he has dropped the proceedings.
Where from you are saying drop the proceeding?
Lordship, because this respondent number 2 thereafter did
Then
not.
come to page 61.
Page 61 is Lordship respondent number 3. The same proceedings he has also initiated.
Hmm?
Lordship may kindly see, it is 148 AB. One notice cannot be given twice. Lordship, 58, already 148 AB notice has already been given. Page 58.
Let us read 58.
Page 58, Lordship. Notice under clause B of section 148A of the Income Tax Act. This is, Lordship, notice under section 148AB. Same notice, Lordship, is at page 61. notice under clause B of section 148A of the Income Tax Act. (48AB), same notice has been given, Lordship, for the same assessment year 16-17, Lordship.
Come to page 62, madam.
62, Lordship. Kindly refer to a reply in response to your so-called notice dated so-and-so, wherein time of 10 days has been short. In this connection, time of further 10 days is allowed for you to respond to the said so-called notice. Your compliance is therefore fixed on or before 15/3/2023.
Don't make such submission.
63 is the second notice. I'm really sorry. Because it was in continuation.
Don't,
I'm so
don't
sorry.
do such
Lordship, responding to
submission.
this was my wrong submission, Lordship. 63 is the second notice, Lordship. 63. 25/3/2023. Lordship, that is the notice by the respondent number 3 this time. Earlier it was respondent number 2 who have given me 10 days time. This is by respondent number 3. Lordship, this I have made a specific statement that I had escaped assessment. This escaped my Lordship notice because at that point of time the college was closed. Lordship, I am a college, Lordship. So that is this escaped my attention, and Lordship, 12/4/2023 the order was passed. Anyhow, Lordship, this order ought not have been passed because this was time barred, Lordship, firstly. But Lordship, because the time limit for passing an order of assessment is, Lordship, 4 years plus 2 years, that is maximum 6 years. But Lordship, in this case, Lordship, there might be a controversy because Lordship, this is relating to 2016-17. So for 2016-17, whether the provisions applicable at that point of time will be applicable or the new provision will be applicable, that is a question. There is a Lordship confusion. So I don't want to go into that. Otherwise, if the provisions that were prevalent at the time when 2016-17 was there, Lordship, it is time barred. But if new provisions are taken into account, then Lordship, this notice will not be time barred, Lordship. But Lordship, this notice will anyhow be bad because this is a notice for reassessment, Lordship. They have given me order under section 148A(d) along with notice under section 148.
Which notice you are impugning here?
Lordship, may kindly come to page 67. 67, Lordship, last paragraph.
But what about this order? Page 65 order?
Lordship, this order, this is the last paragraph of this order only. This is the order which has been passed, and Lordship.
Page 65, what is this order?
Lordship, this order has been passed. They are, Lordship.
As for information.
Earlier, Lordship, directly 148 notice for reassessment used to be issued. Lordship, there was a judgment of the Supreme Court in GK and Drive Shafts, which said that before issuing a notice, you issue an order under section 148AD. This was a judgment. So that
what is 148?
Lordship, it is turnover escaping assessment. Lordship, may kindly see section 148.
When income escaped assessment.
Income escape assessment. Lordship, this is to assess income under section 147 before making assessment or recomputation under section 147. This is 148 notice.
Conducting inquiry, providing opportunity before issue of notice. Before issuing any notice under section 148. You have being hard for serving upon a notice of so much in such time as may be specified in that notice. Evidence but not exceeding.
So, Lordship, section 148 notice is issued for income.
148A clause B.
Yes, Your Lordship. Conducting inquiry before the issuance of so-called notice under section 148. That is the, this is the inquiry. Decide on the basis of material available on record, including reply of SSC, whether or not it is a fit case for issuance of a notice.
So let us read 148A.
Yes, Your Lordship. 148A.
A.
Yes, Your Lordship. 148AD only I am reading, Lordship. Conducting inquiry.
No, 148A.
Yes, Your Lordship. 148A.
A. Read fully conducting inquiry, providing opportunity before issue of notice under section 148.
Yes,
now, assessing officers shall, before issuing any notice under section 148B, provide an opportunity of being heard to the SSC by serving upon him a notice to show cause within such time as may be specified in a notice, being not less than 7 days, but not exceeding 30 days from the date on which the such notice is issued, and such time as may be extended by him on the basis of an application in his behalf as to why a notice under section 148 should not be issued on the basis of information which suggests that income surgible to tax has escaped assessment in his case for the relevant assessment year and results of inquiry conducted, if any.
Lordship,
C, consider the reply of SSC furnished, if any, in response to the show cause notice referred to in clause B.
D.
Then
will be-
decide
Lordship,
on
D
the
will
basis
be
of
important.
materials available on record. Now let us see the how proceeding has
Lordship, D is important.
proceeded.
Lordship, D is important.
Let us see. This is only opportunity of providing opportunity.
For Lordship, na.
Page 58.
Before issuance of no super notice.
Before issuance of notice under 148. Let us go one by one. I am not very conversant with income tax law
Lordship,
like Madam Havelia.
Lordship,
Then
before
this
issuance of
was then you sought time by this application
Yes, Your
according to that.
Yes, Your
Also, then he granted time by page 61.
Opportunity.
Region was there.
Yes,
Then
Lordship, thereafter page 61, Lordship, na, they granted me time, then 63, Lordship. 63, another notice, 148, 8.
yes,
notice.
where is the bar?
There is no bar.
No bar.
No bar.
No bar.
This notice
Then
has no problem.
what happened to this notice?
Now, Lordship, this is the.
What happened? Did you file any reply?
No, Lordship, I did not file any reply, but.
Then
Lordship,
this order, how it is time but
Lordship, that is now, Lordship. Lordship, may kindly see that this
what is the order last part?
last part, Lordship, page 67, last
Let
paragraph.
us understand.
Page
as
67,
per
last
in-
paragraph.
There
Given,
is a which has been flagged in the
Lordship, given the above narrated
following
facts,
final
it is evident that
transaction
the
during
income
the
tax
year
is
relevant to the assessment year.
Hence,
What he said,
hence,
after so and so,
hence, it-
SSC was given an opportunity to explain why notice and should not be issued.
yes, Your Lordship,
Accordingly, this
Lordship, opportunity was given to me. I cannot
show
deny.
cause notice was issued, served in the SSC electronically, though the show cause notice and opportunity was provided to furnish a reply. And shall not be treated as income service so and so. This is the meaning of sales and interest of a show cause as so and so. Accordingly, for the 10 days time, show cause notice was issued, giving time. After it is presumed that it is final, has no explanation. However, lapse on the part of the not filing and so and so surgically means that any institution referred to in the 2-3 will be required to file ITR.
If it exceeds the maximum amount not chargeable to tax, I'm not.
So whatever he has recorded,
Sir, Lordship,
after providing opportunity to you, and he has recorded that notice under
148.
148
Ah.
is sustainable.
Sustainable.
Is a fit case. That
Fit
is
case.
what? Because of your non-response,
Yes, sir.
right?
Lordship, I accept that this my opportunity of hearing was, even though I may have reasons, but my opportunity of hearing they have provided to me
Yes,
very
that,
duly.
you
is-
cannot
that
blame
is-
now that,
I cannot deny.
you cannot blame him, right?
I
Now that is, now comes the stage of 148. What is 148?
Lordship, section 148, Lordship, now they have said that it is not 148 notice is issued. Last paragraph says.
Before
148.
making assessment, reassessment or recomputation under section 146 and subject to the provisions of the notice along with a copy of the order passed if required under clause D, requiring him to furnish within a period of 3 months from in search.
This 148D, Lordship, order was given to me along with notice. So Lordship,
Such
148
order
notice
has
has been
been
given.
allowed a return. Shall serve on the SSC a notice along with a copy of the order passed.
Or this was the order, Lordship, and the notice.
Requiring to furnish within a period of 3 months. The notice is issued from the end of the month in which such notice or such period has been returned with income. Okay, then what is the nature one intimation?
Lordship, third. Lordship,
Now this, where is that 148 notice?
Lordship, that 148 notice, Lordship will find that along with the order, they have in the page 67 only, in the bottom, Lordship. Page 67 bottom, 68 bottom, 67 bottom.
Notice under 1648.
Yes, Your Lordship.
Yes.
This is the notice under 148, sir, Lordship,
Ah.
along with that. So Lordship, 148.
Meaning thereby you were granted 3 months time
3 months time has been given to me. Now,
from the end of the month.
yes, your Lordship.
That was in which month?
Lordship, April.
April 2023.
Now, Lordship, then thereafter they realized two things, Lordship. The first thing was, Lordship, this I'm not only for your Lordship this purpose. Lordship, first thing that was realized by them was that, Lordship, at page 66, your Lordship will see. The deposit is not my account, Lordship. It is Mangal College branch. Lordship, I see page 66, which they are doubting. Not not this full law college. This is some Mangal College, page 66. So one thing that is, they realize this. This is only one merits of the case I'm saying, Lordship, which is not which I'm not submitting at this moment. Lordship, I'm only submitting that this notice which they had given to me was for reassessment. So, Lordship, I pointed out that without doing an assessment, you can't give me an order of reassessment. For this, Lordship, I placed 2 lines of judgment of this division bench of this honorable court.
No, that initial notice,
Yes, your Lordship. Lordship, the
the
notice is-
initial notice mentions about what?
Lordship, that
That annex of 59?
page 59, na? Lordship. 59 says about some United Bank of India Secretariat Dispute Branch.
Ah.
And again, United Bank of India Head Office. That is the second amount is not mine relating to me.
No, that was not mentioned here, but it was
Now it is mentioned.
information amount paid credited to whatever 5 lakhs so and so and 11 lakhs so and so.
Amount was also changed, Lordship. This was 5 lakh and 11 lakh. Now when 140, Lordship, that this order was passed at page 66. Amount has changed and the.
Oh, Mr. Gogoi, what is this? You started from the proceeding in respect of this annexer 59, page 59. Page 59. Come to page 59.
53.
59.
Lordship.
Initially, you started the proceeding for these 2 transactions.
Lordship.
Is it not? Page 59. See the amount. 5,32,770 or so and so. Then their page 60 is their application seeking time.
Lordship.
Then according to page 61 and 62, they had granted time to the petitioner, right?
Lordship.
And finally,
67.
63 again. 63 again.
Lordship.
Then again 64, come to page 64. Annexer indicates 2 amounts,
Lordship.
right? I think page 65 is the culmination of the proceeding under section 148A.
Lordship.
148A by virtue of power under clause D.
Lordship.
There you reflect, compare page 64 and 66. Page 64 and 66. Compare the 2 tables.
Lordship.
Is there any?
Different.
Why? You started for
Mongoldoy.
A, but you have reached B.
B.
That is a violation
Lordship.
of
yes.
natural justice.
Lordship, here in this case, what my learned friend has argued, whether they have given reply on that executing authority. If it is
Okay,
there-
no,
Now-
no, okay, admittedly, no. They did not furnish their reply under clause C.
then it is
But
presumed-
whether you have the power, initially you started the proceeding under clause B for rupees 2 lakh and 5 lakh
Five.
and 11, how much? 2, 3,
One
1 crore 18 lakh. Keep open 64.
Lordship.
1 crore.
Okay, let us assume they did not furnish any reply. But whether that will empower you to reach some finding as regards 25 lakh and 1 crore 57 lakh, mentioning some other transaction.
That's it.
Huh?
No,
That appears to be non-application of mine.
no, it should be, we have done the contraction under form 26 AS. Under information of 26 AS, the source of income has been assessed.
No, how can you reach at another destination? You
That
are
is-
going for Delhi, but you have reached Bombay.
That is a problem.
Before reaching Bombay, he should be given the opportunity. Now this is experting. This part is expert 25 lakh, 1 crore 57 lakh. How you have reached?
The release is in there, if Lordship permit me, page.
Then thereafter what happened?
Lordship, thereafter they have issued me notice under section 148. 148 is for reassessment. Now, Lordship, reassessment, Lordship cannot be given without assessment. So now they realize that, okay, the assessment was not done. So now they have given me 69 intimation for assessment. They are not sure whether they are going to reassess me or assess me. They have to first assess me, then they can reassess me. So this 148 proceeding, they started for reassessing me. Now they have given me intimation for assessment under section 144B. 144B is relating to, Lordship may kindly see the intimation is relating to 144B. Annexure 6, page 69. That is, Lordship, 144B that they have given to me. Lordship may kindly see 144. It relates to assessment, not reassessment. Now they have started assessment proceedings because they know that without assessing me, they cannot reassess me. 144B, Lordship, if your Lordship will see.
No, they reached a finding that you should be given a notice under section 148.
148.
Issue of notice where income has escaped assessment.
That they have given to me, Lordship. But now they have given me again a notice under section 144B. Lordship, may kindly see.
1 minute. Now, when 148 notice was issued to you,
Yes, your Lordship.
did you respond?
Lordship, so far as
No,
my-
I'm asking, did you respond or not respond? Yes or no?
Lordship, so far as if on record, if it said that I submitted any reply, no, Lordship. But if you had said that I visited the officer and said that you have not.
Visited the officer will not
That
do.
is what, Lordship.
Don't say that.
That is what, Lordship.
Did
No,
you
Lordship.
respond effectively? No. Then what is the consequence then after 148?
Lordship, they did not do anything because they realized that assessment has not been done. So now they have given me 69 for assessment now. That was time, but also without assessment, they could not have given reassessment. But 69 they have issued. Lordship, may kindly see intimation to assessee for completion of assessment.
What is 144B?
Yes, your Lordship, may kindly see 144B, that is faceless assessment. This will make everything very clear, Lordship. Lordship, may kindly see 144B, that is faceless assessment. May I read, Lordship?
148 is for assessment only.
For reassessment.
Oh,
No assessment. And 143.
Please read 148.
148, Lordship. Lordship, 144B is for assessment.
Please read 148.
Yes, your Lordship. Issue of notice where income has escaped assessment, Lordship. Before making assessment, reassessment or recomputation under section 140.
So no, it is not only reassessment.
Lordship.
It includes assessment, Ms. Howell, yeah?
Lordship,
The word itself, issue of notice where income has escaped assessment. That means there was no assessment.
no assessment, Lordship.
No assessment, right?
Yes, your Lordship.
Before making the assessment, the word itself, the first word itself is clear before making any assessment. Just because I'm not conversant with the income tax laws
No, Lordship, I will, Lordship, explain it.
does not mean that I will not understand it when the provision is read.
Lordship, Lordship, I will read.
Am
the-
I making itself clear?
No, Lordship.
It includes assessment as well as reassessment. Here, it is a clear that after 148A proceeding, they have reached a conclusion that 148 notice should be issued,
Yes, Lordship.
meaning thereby it might be assessment or reassessment or recomputation, whatever.
I will satisfy your Lordship.
Then this is the order which is not challenged anywhere. This page 67. 67 end. It is a fit case for issuing notice.
Yes, your Lordship.
So it amounts to notice under section 148.
It
So
will-
assessment.
Yes, your Lordship.
Now, what is 144B? It is faceless assessment.
Faceless assessment under section 143 or 44. Lordship, may kindly read the section, only 2-3 lines, Lordship, if your Lordship will permit me to read.
So not,
Lordship, I'll satisfy everything, Lordship. Maybe I am not able to.
no,
make my-
read 144 first line itself.
144B, Lordship. Faceless assessment, notwithstanding anything in the contrary contained in any other provisions of this act,
Hmm.
assessment under subsection 3 of section 143.
Assessment
Yes.
or reassessment.
No, reassessment is.
144B is faceless
Yes, sir.
assessment.
Yes, your Lordship.
So it says about assessment only.
Assessment only.
Ah,
Yes, your Lordship.
yes.
Yes, your Lordship.
Read slowly, notwithstanding
Anything
anything to the contrary.
contained in any other provision.
So non-obstante clause. The assessment.
Under section 143.
If I am taking up an old book,
Lordship, what is the year of the book, Lordship?
2023, 2024.
Lordship, I am taking 21.
Notwithstanding anything,
To the contrary, contained in any other provision of this act.
the assessment, my book says,
Yes, your Lordship.
reassessment or recomputation under subsection 3 of section 143, leave it aside, or under section 144 or under section 147, as the case may be. With respect to cases referred to in subsection 2, shall be made in a faceless manner as per the following procedure. Now,
Actually, amended. There's an amendment.
whether 148 proceeding is permissible under 144B.
Lordship, if Lordship 140, so Lordship, since after this amendment, it is possible, Lordship. If after this amendment, it is possible, Lordship, this amendment which your Lordship has Lordship pointed out regarding 147, after amendment, it is possible. Lordship. Because 148 refers to 147 and 147 is already given under.
The finding was this for issuing of notice under 148. Right?
148 refers to 147, Lordship.
148 refers to 147.
Yes, Lord. It is for 147 only, Lordship. 148 notice is.
Income is okay. So
148 refers to.
now about your submission regarding time bar. Otherwise, this is going on as per the provisions of the Income Tax Act. So far, I have found privacy. This notice is also, is there anything regarding time barred?
Time bar, so far as time bar is there, Lordship, as per the provisions which is applicable in respect of the year assessment year 2016-17, Lordship will kindly see section 149. It has been amended now, But so far as Lordship 1670 is concerned, Lordship will see the head note, the footnote. The
Time
finance-
limit.
Time limit. For notice under section
1
148.
minute. Oh, notice and will be issued for the.
If your Lordship will read the Finance Act, the amendment before the Finance Act 2021, the footnote will be there. 21, it was amended, Lordship.
21 or 22?
Sir, Lordship, the Finance Act 2021 amended it. After that, 22 also might be amended, but by Finance Act for 2021, Lordship.
Okay, 21. Okay, fine limit. No notice
148.
under shall be issued for the relevant year. As well, if 4 years have elapsed from the end of the relevant, unless the case falls under B.
Will fall under B, Lordship.
B.
Yes, Your Lordship. Not 4 years. More than 4 years. They are saying that we have suppressed. C will,
1 lakh.
C will, 1 lakh or more, Lordship, or more.
Ah.
Mine is more than 1 lakh.
So it attracts.
It, B,
Hmm.
B. So B will be, Lordship, 4 plus 2, 6 years maximum. Maximum 6 years. From the end of the, Lordship may kindly see from the end of the assessment year.
Yes.
End of assessment year is 31/3/2017. So 6 years will, Lordship, end on 31/3/2023. My notice has been issued after that.
Which notice? This 69 notice?
Lordship, that 148 notice, which was issued to me 12/4/2023 after this order. 12/4, that is issued on 12/4/2023.
12/4?
2023.
Twelve for 2023.
Yes, Your Lordship. And Lordship, the time limit ends on 31/3/23. If Your Lordship considers end of the assessment year and
But otherwise, substitute. But that is one, that was an amendment in 2021.
yes, Your Lordship,
But there was an amendment in 2022 also.
there are
That
whether that will be applicable to my 16/17 year, that is a question, Lordship. That is why, Lordship, I said that there will be
because that is 10 years.
if Lordship, the new amendment is considered, then Lordship, it may 3 years or 10 years. If they say I have not suppressed anything, then 3 years. If they say I am suppressed, then 10 years. Less than 50 lakhs, Lordship, 3 years. Less than 50 lakhs is 3 years.
3 years. In either case, it is 3 years.
Yes, Your Lordship.
Or 4 years. 4 years. Earlier 4 years, now 3 years.
3 years, Lordship.
And
Lordship,
so far 22 is concerned, amendment is concerned, it is likely to amount to 50 lakh.
50 lakhs. My is less than 50 lakhs, but still if I consider B, then it will come to more than 10 years. If new provision is attracted. Lordship, but in my humble observation, because it is relating to 16/17, old provisions will be attracted in this case. That is a Lordship, but subject matter of Lordship consideration before various high courts.
Yes, Mr. Gogoi.
Lordship, here in this case, the all opportunity have been available to them.
That's okay.
They have been failed. Now, it is presumed that they will likely escape their liability. That's why the faceless assessment has been done, Your Lordship. Even in the assessment in the space 6.
No, firstly, you have done I don't know, from the record itself, you started from destination A, reached somewhere else. That is one apparent.
That is one
Some Mongol song. That is one. That appears to be non-application of mine.
No, why?
Primarily, primacy. Then you started this 148 notice with this Mongol college and some transaction and different amount.
That part I will take specific instruction if Lordship permit me.
You should take permit.
Because
take permission. appears to be on wrong footing. Dispute law college and you are proceeding.
Why it has been done, your lordship, that is a point of issue. Might competent department never be do such type of things because
That is what apparent from the document. It is your document. Your document.
that I have seen.
If
your
you
lordship.
compare these two, then you cannot do this.
That is not permissible.
That is not application of mind. And secondly, that issue may be some, whether it is procedural. And procedural will, no, that period, extension of period is procedural, that is a issue, that is legal issue.
Legal issue.
But so far this is concerned, this is apparent.
Then I will take instruction, lordship. Lordship satisfied, I will give why it has been done in the 2 point of destination.
Is it an appealable order or not? Or a time limit has expired?
Not yet. This is not.
This notice, 148 notice,
This is not.
is not an appealable order. Okay.
Faceless assessment has been done, no any result. If lordship permit me, page 69. Page 69, lordship, paragraph 3. Who has barred? No one has barred. You are advised to periodically check your account in e-filing website and give specific reply to communications notice issues within specific time. This will enable passing for of fair assessment order after due consideration of your reply explanation.
So after that, what is the procedure? 144B, Ms. Hawley?
144, your lordship.
Hmm?
You will go to the base assessment.
144B, and what is the procedure? Faceless.
Lordship,
You have
then,
been given the option to reply.
Yeah, they can participate.
Lordship, then we'll have to participate and then by 148 Lordship, then I cannot challenge. Once I participated, I cannot challenge 148.
No, 144B.
Yes, your Lordship.
Now, after intimation,
Yes, your Lordship.
what is the procedure?
Lordship, they will assess me.
One,
We will produce all the papers and documents in faceless manner. They will not see me, means I will not know the officer.
that's okay, but whether he has the jurisdiction to consider it legally?
Lordship, if the 148 notice is wrong, Lordship, then he cannot. This, if 148 notice is wrong, that order along with the notice is wrong, then he cannot, Lordship.
Well, the case may be, see, if there is requirement on the part of that officer to apply his mind,
Yes, your Lordship.
then he should apply his mind. Why should we interfere here?
Lordship, if Lordship, this is not taken care of here, Lordship, I cannot challenge it afterwards. My right to challenge goes away. Once I participate in the proceedings, which the notice which has of intimation which has been given to me.
No, whether this provision, it is a long provision, 144B.
Yes, Lordship.
Where is the provision, how he is to consider your reply? Let us see.
Lordship. Lordship, section 144B.
Because we are in now 144B.
Yes, your Lordship.
Yes.
Lordship, kindly see subclause 3 of clause 1 of 144B. Where the SSC has furnished
Clause?
of income. Then Lordship,
We are into 144B.
yes, your Lordship.
Ah.
Lordship, if 144B subsection 1,
Subsection 1, we have seen.
subclause 3.
Hmm.
So Lordship, now they will see whether I have furnished my return or not. If I furnished my return, then Lordship, A will follow. Since I have not furnished my return, then
3 or what? 3.
3 subclause.
A notice shall be served on the SSC through the National Faceless Assessment Center. And the section 143, subsection 2 of section 143 or subsection 1 of section so and so, and the SSC may file his response to such. So it shall forward the same to the assessment unit. It may make a research to the science for obtaining such information, conducting and verification. This is it has been initiated by the other.
Then Lordship, all this procedure, they will issue me notice, they will hear me. And Lordship, thereafter, I cannot challenge this 148 notice. issued to me. And this is my right, Lordship, as per GK and Rights Acts of the Supreme Court. This is my valuable right.
Which one?
148 AD order which they have passed.
Hmm?
148 AD order which they have passed. That's my valuable right.
That has been passed because of your non-response.
Now 144B.
That right you cannot now, after without that right now you cannot avail. You have invited that situation. Admittedly. Now, whether this authority during this 144B proceeding has the discretion to drop the proceeding or not?
No.
Huh? Okay. Whether he has to apply his mind if a response is filed to this notice.
Lordship, he cannot drop the notice. He has to
See, otherwise, if it is there, discretion is available to the authority, then we will not entertain this writ petition. Only observing that, let him exercise his discretion. And he can exercise his discretion whether it is time barred or not time barred. I have not gone through it.
That is not
Long provision. Mr. Dr. Gogoi,
let him take up this instruction, Lordship, in this regard.
find out whether he can apply his mind or not.
Yes, sir.
Yes, your Lordship.
Show me the provision. Yes, no, not do.
Take the instruction.
I have to take a.
Go through the provisions, that's all.
144B, your Lordship.
It is a long provision running into 5 pages. It is difficult for me to find out. Get it. You go through it,
Yes, your Lordship.
madam. Find out which are the provision, how he is to apply his mind
Yes, your Lordship.
after issuance of notice and receiving a response from your side. And if it is time, but if he has to do it, okay. Otherwise, there are many provisions. It is to
Lordship, time barred, Lordship, the officers cannot to go through, they cannot, Lordship, decide whether it is time barred or not.
show me what provision now, which one will apply,
Yes, your Lordship. I will, Lordship. I will really have to go through it.
which provision is apply. You find out something. Otherwise, your case is falling. Your case is falling within the provision unless this amended provision is not applicable. Then you may escape. But if the amended provision is applicable, you have to submit to the jurisdiction. Find out that legal issue.
Sure.
Otherwise, it is procedural part of that extension of time limit will give revival to them.
To reassess.
To reassess or assess. That you find out something substantial, come out with something substantial. But take me through the events correctly.
Yes, your Lordship. Yes, your Lordship. First,
So that judicial time is not wasted.
I will.
Heard MS and Harley
In the meantime, I also take instruction also. That also be put.
and Mr. Dr. B.N. Gogoi, learned standing counsel, GST, for all the
No, Lordship, Income Tax Department.
income tax, for all the respondents, full stop. Both Mr. MS Havilia and Mr. Dr. Gogoi have sought a week's time to complete their instructions. Let the case be listed again on so and so day.
20.
So Monday. Motion. Oh, my team. Wednesday.
And diploma.
On this legal issue.
Only on this.
Please, my lord, I beg to apologize, my lord. My lord, the eviction matter which I had mentioned in the morning, the cars have already come, my lord, for eviction, if it may be taken out. My lord, the eviction matter which I had mentioned in the morning, my lord, it was pleased to allow it. Unlisted, my lord, the eviction people have come, my lord, to carry out the eviction drive. If it may kindly be taken up, my lord.
I should.
I am sorry for mentioning it this way, my lord. Extremely sorry, my lord.
When the notice was served, tell me.
My lord, 5/11. Impugn notice.
Okay. 5/11.
Production list 3. Item 3. County command.
Item 3, production list.
Yes.
My lord, may it please, my lord.
Are you representing the respondents? MS Borua? Hmm? Yes, what is your case?
May it please, my lord. My lord, we were in possession of a khas land, my lord, located in Gwalpara, my lord, Dudhnoi Circle. My lord, from the last 20-30 years, we have been living there and we also operate our shops there, my lord. Thereafter, my lord, about a year ago, there were certain activities from authorities, my lord, owing to which certain markings were done in our land. However, my lord, we were not aware we were not given any notice or we were not made aware when this eviction drive would be done. Later on, my lord, it came to our knowledge that it is for the expansion of the national highway, my lord, from Paikan to Dudpara, my lord. My lord would kindly have the impugned order at page 68 of the writ petition, my lord. This is a communication between the Additional District Commissioner Gwalpara to the Circle Officer Dudhnoi Revenue Circle, my lord, wherein our page 68, my lord, 68 of the writ petition, my lord.
No, firstly, tell me,
My lord.
what are these applications 54?
My lord, this is for the compensation, my lord. But my lord, we are.
Tell me first,
Yes, my lord.
what are the proceedings,
My lord.
previous proceedings?
My lord, previous proceedings did not take place as per section.
No, why you are asking for release of compensation?
My lord.
Page 54. I don't know who are you, but there I have seen it just while going through these pages.
Yes, my lord. My lord.
What are these applications?
My lord, this is for compensation, my lord. What has happened, my lord, when we came.
Indicating it is suggestive of that there are
Land is going to get acquired, my lord.
it is indicative of some previous events.
My lord. Because my lord.
Why these applications are yours?
Yes, my lord.
These applications are yours.
Yes, my lord.
Then you are asking for compensation.
Yes, my lord.
Right?
Yes, my lord.
Now, who are the? Show me some official document.
Yes, yes. My lord would have my representation at page 50, my lord. 50 onward it starts, my lord.
Regarding clearance.
Before the additional deputy commissioner Gwalpara, my lord.
50.
50 onwards. No.
Where are the notifications?
My lord, that we don't have, my lord. What has happened in the case, my lord? As
now, how you are asking?
My lord, may I kindly substantiate that?
It is a case of construction of national highway.
Yes, my lord.
Meaning thereby, I have found that they never fail to issue notifications as a 3A, 3D, 3E, all, right? And gazette publication as well as paper publications.
Yes, my
they
lord.
never fail.
Yes, my lord.
Now, where are those?
We didn't have knowledge of the same, my lord.
That is not a case to be set up before the High Court. That no knowledge. When gazette is there, no knowledge is not a case to be set up because you are asking for compensation yourself.
Yes.
Against specific DAG number,
Yes,
even.
Yes, ma'am.
Don't play such thing. You are asking for compensation against your motor parts garage covered by DAG number 369.
Yes.
Hmm?
Yes, ma'am.
Why you are asking for compensation?
Because it came to our knowledge, my lord, that our land.
Came to our knowledge. You are participating before the additional deputy commissioner Kala. Right?
Yes. My lord, may I kindly submit, my lord? I have taken an averment to this, my lord, in my writ petition, my lord. My lord would kindly have page 8 onwards, my lord. I have substantiated my justification in this, my lord. My lord, as per section 3A, my lord, the publication is done in 2 newspapers, my lord, as my lord had indicated, my lord. Thereafter, my lord, as per 3B of the National Highway Act, my lord, surveys are conducted. That was also done, my lord. In fact, the authorities had come and they had marked in our shops and houses, my lord. Thereafter, my lord, what had happened, my lord, if we had any objections, we had to file it under section 3C of the Highway Act. Now, my lord, because of lack of knowledge, my lord, I have taken an averment to this, my lord. You would kindly have page 9, my lord, for a moment. Page 8, if I.
So what is the stage, present stage under the National Highways Act?
My lord, under the National Highways Act, my lord, right now, my lord, they have come to evict us from our land. In the impugned order, it is categorically reflected that we are entitled to compensation for the structures and the jirat present in our land, but that has not been given to us, my lord. And the impugned notice is of 5/11, my lord. As such, we are handicapped today, my lord. Only till the time, my lord, our compensation is not paid, we may be.
That is
allowed
not
to
a case here, National Highway Act.
My lord.
Come to 3D.
Yes, my lord.
CD2.
Yes, ma'am. On the publication of the declaration under subsection 1, the land shall vest absolutely in the central government free from all encumbrances. My lord, my lord, it is there, my lord, and we had not filed the objection within 21 days, my lord. That is our fault, and I have also stated it in
Then
my.
come to 3E.
Yes. Power to take possession, my lord. My lord.
If you want some time, there is a different matter for vacation, to vacate or to go out of the land, because if you want to remove the structure on yourself, that is a different issue altogether.
My lord, may I kindly submit, my lord? That is what exactly I am praying for today, my lord. Some time may be given to us, and the compensation we are not given, my lord.
Compensation will be given under 3G. The stage will come later on.
Yes, my lord.
Right?
Yes, my lord.
You are included.
Yes, my lord.
Zirat compensation will be paid.
Yes, my lord.
Otherwise, there are other proceedings, 3G. Then they are under that, if you are excluded, you can prefer it before that. But question is, you have been surveyed already.
My lord, we have been.
Already, all structures are marked.
Yes, my lord.
Right?
We have been marked.
Right.
Yes, my lord.
Then 3D, then 3E, then absolutely vested. Absolutely vested. No doubt about it. Then 3E, they have to take possession. Right?
Yes, my lord. My lord,
So you have not included all these notifications, but from your application it is clear.
my lord, some time may be given to us to at least make an alternate arrangement.
But the huge, sir,
My lord.
there are huge movement.
My lord.
Huge movement. Are you ready to pay the cost? These officials are coming. Are you ready to pay the cost? Then it will eat into your compensation amount, mister.
My lord, may I kindly take instruction in a minute, my lord?
Yes. Huge cost, man and machinery. Government machineries are moving. Additional Deputy Commissioner, SP, all are moving. It cannot be like that. And you are aware what is coming.
Yes. My lord, may I kindly obtain the instruction within a minute, my lord? I'm deeply obliged.
Lordship, one thing is there.
Yes.
Their notice was given just to clear all this. Their shop is there in the right of way. So the people, they did not allow this department actually to go ahead with the construction work. So it's a national.
Force will be
project.
employed. What else to do? They are given notices. All are there. They are asking for compensation. That stage is not, disbursement is not there. That stage has not come yet. But after 3D, absolutely vested. And they have to give way to the position themselves, otherwise force.
Yes, that's
We have
why
to
Lordship,
go by
they have
that.
to- they-
And that is right of way.
But they have to go ahead with the construction work, Lordship.
And what the Supreme Court yesterday has? Force. Yesterday, I think, by the Honorable CJI.
Notices were given in the 23, Lordship. They were very much aware of.
What the Supreme Court has held, I'll go by that.
My lord, 1 minute may be given to me if they.
No 1 week. Come after the break, I'll take that Supreme Court judgment. Right of way. If they are not vacating themselves, use force.
Item 11.
I have to go by that observation.
Deeply.
What is this?
Yeah, this is regarding partition and demarcation of the land measuring purview of 4 kata and 14 lessa, my lord. This is the second round litigation, my lord. Page 37, the earlier order passed by your lordship, my lord. Page 37. It started from part 37, my lord, operative page 43, my lord.
You are asked to approach under
Yes, my
right
lord.
to public services.
And paragraph 7 also directed to make partition.
This is additional relief you have been granted
Yes.
by
then-
this court.
Then my lord, page 44. I have submitted the application, my lord, along with the.
Why you are coming here? An appeal under section
Yes,
8.
Appeal also filed, my lord.
Appeal filed. Then what happened?
Then in the appeal, my lord, the deputy commissioner, page 52. Page 52 direct.
Reference to I am forward here with the copies of the prayer petition. It's demarcation. Yes, Mr. Goswami.
Then, my lord, after receiving this, my lord, the circle officer again asked to submit an online application, my lord, page 53. Accordingly, the petitioner submitted this online application, my lord. After that, my lord, the circle officer on official an order was passed. But practically, he has not completed the partition and demarcation, my lord. Page 54, my lord, the order.
Page 54, the order.
Yes, my lord.
What he said?
Here, my lord, land records, my lord, submission dated 27/8/24.
Partition on paper is done.
Yes, my lord, this is a partial partition, so the DAC number and patta number will be changed. That order was passed on, my lord, 27/8/2024. But practically, he has not completed the process, my lord. This is our prayer, my lord.
Mr. Goswami, you take instruction. Otherwise, he has other remedies. This personal circle officer has to pay from his salary. Before going to that aspect, please take instruction why he is not acting despite Deputy Commissioner's direction. Otherwise, we'll make him pay from his salary.
I'll take instruction.
Heard Mr. M. Hussain, learned counsel for the petitioner, and Mr. N. Goswami, learned counsel, junior government advocate Assam for the respondent number 2, 3, and 4. Also had MSP amount of learned standing counsel revenue and disaster management department closed up. The petitioner has preferred an application seeking the public service, notified public services of demarcation and partition.
Partition.
Perfect partition.
Perfect.
Perfect partition. Under the provisions of the Assam Right to Public Services Act. Portion 2. An order.
My lord, imperfect partition, my lord, because we are two person.
Portion 2. Demarcation and partition. Portion 2. An order dated 21/3/2023, passed in a writ petition. WBC number 6158/2022, earlier preferred by the petitioners.
Actually, my lord, in the earlier occasion, my lord, the petition number 2, 1 is the petition, was the petition number 2, my lord. And in the meantime, my lord, the petitioner number 1 died, my lord. Accordingly, that 2 to 3 are the legal heirs of petitioner number 1, my lord.
Okay. Full stop. When the notified services were not as notified services as sought for, was not extended to the petitioners, the petitioners preferred an appeal before the appellate authority, that is the district commissioner, Dhubri. Under section 8(1) of the Right to Public Services Act, 2012, post of the appellate authority, the district commissioner, Dhubri, has directed, on 15/5/2024, to the circle officer Bilakipara Revenue Circle to take necessary action as per rules. Post of. Thereafter, the circle officer Bilakipara Revenue Circle has passed an order of partial partition in respect of the plot of land in question, post of, on 27/8/2024, post of, but, demarcation, field demarcation,
Field demarcation, record demarcation also not.
and field demarcation has not been carried out till date. Post of. Furthermore, the revenue records are not corrected till date. Post of para Mr. Goswami Leonard, Junior Government Assam, representing the respondent number 234. Representing the respondent number 234 shall obtain instruction for the same respondents as to why the necessary steps as proceedings initiated for demarcation and partition are not brought to its logical conclusion till date. List the case so and so on next week, Monday, 18, in order to enable Mr. Goswami to obtain instructions. Post up, Mr. So and so, and counsel petitioner shall furnish an extra copy or two extra copies of the writ petition along with an extra to Mr. Goswami during the course of the day to enable him to obtain instructions in the matter.
My lord, partition and demarcation, my lord.
I have said partition.
Obliged.
Been told by the lawyer that his marriage is fixed on 20th November. The file is item 49.
49?
49. And the lawyer's marriage is fixed on 28th. So file is with him. So matter may be listed after 2 weeks.
Okay, on the prayer of Mr. M.U. Marvel, the counsel petitioner list the case after 2 weeks.
How like?
Ms. G. Hazarika, Revenue, and M. Borman, so and so are paid.
May I please, your lordships. Item number 36. The affidavit has been given by the respondent, but I said to file a reply, your lordship. So 4 weeks time may be granted.
R.M. Sudri, petitioner, has paid for and is granted 2 weeks time to file an affidavit in reply to the affidavit of petition made by the respondent number. Respondent number?
I am for the petitions.
Who filed the affidavit of petition?
Respondent number.
Okay.
Moving on against method, item number 1.
May it please your lordship, I'm appearing on behalf of my senior and.
Yes.
Petitioner.
We are for the petitioner, your lordship. Please.
You are not audible.
Yes, your lordship, I'm appearing on behalf of my senior and Longkumer, your lordship. Please kindly pass over the matter on Monday since my senior is in this post.
When do you want?
Lord, Monday, on Monday.
Yes.
Monday.
Monday, not possible. There are other matters. Some other day.
Dates which is convenient to the court.
Come to an agreed date. In the week commencing from 25th November.
Okay, your lordship.
When?
25th, Monday.
Okay. Your name is madam?
Kim Piana.
Would you love? Learned Counsel representing Mr. N. Longkumar.
Yes, your lordship.
Learned Counsel for the review petitioner has made a prayer for adjournment. Mr. M. Chen, Learned State Counsel for all the respondents.
Im Song.
M. Song, Learned State Counsel for all the respondents is present. Trial labor, this court proceedings is held through virtual mode. In view of the prayer so made and as agreed to by the Learned Counsel for the parties, lays the case on 25/11/2024.
Item 2.
Yes, any counter from the state? Respondents?
Lordship, I have filed my affidavit.
Mrs. Amir?
Your Lordship, I have filed my affidavit, Your Lordship.
Oh, it is not in record, perhaps. When did you file?
Your Lordship, on 5th. On 5th. Your
5th.
Lordship.
It is not in the record. Okay, Mr. Zamir.
Lordship.
Just you have to address one point.
Lordship.
Whether if it is a case writ petition preferred by a large number of persons.
Lordship.
Out of that large number of petitioners.
Lordship.
If a petition for review.
Lordship.
Is filed, whether the entire judgment is to be reviewed or it can be reviewed partially.
Yeah, no, Your Lordship, on that, on the last occasion when Your Lordship was here in Kohima bench, Your Lordship has put a pointed query whether if review is allowed, then whether judgment passed by Your Lordship is to be recalled and the matter needs to be heard afresh.
Yes.
That query, Your Lordship. On that, Your Lordship, in my respectful submission, since the ground on which the review is being sought is not objected to by the opposite party petitioner in writ petition, Your Lordship. In fact, it will be just a formalities on, to recall and to hear the writ petition afresh, Your Lordship.
Okay.
Now on that, Your Lordship, may I just if the order is modified by review jurisdiction, Your Lordship.
Yes.
It will not be necessary to recall and to hear the matter afresh, Your Lordship, my submission. And on that, Your Lordship, I have given some citation.
Yes.
1993 supply.
1993. 1993?
1993 supply for SCC.
Yes.
595.
Okay.
In para 19, Your Lordship.
Para 19.
Para 19, last three line. Last three lines.
Last three lines, para 19.
19. May I read out, Your Lordship? Para 19. Last three line. Is there is the citation before Your Lordship?
Yes.
May I read out?
Yes.
The court is thus not precluded from recalling or, Your Lordship. Or
last three lines.
Last three lines, para 19.
Last three lines. Yes.
The court is thus not precluded from recalling or, Your Lordship. reviewing its own order if it is satisfied that it is necessary to do so for the sake of justice. So it's not necessary to recall the judgment, Your Lordship. It can be reviewed in excess of the plenary jurisdiction of Your Lordship under Article 296, Your Lordship, just to review by way of modifying the judgment in order, Your Lordship. Now, another citation, Your Lordship,
Yes,
is 2014,
2014.
Volume 14 SCC, page 77,
Page 77.
Lordship. Relevant
Yes.
para 26.
Yes.
Para 26, page 91, last 3 lines, Your Lordship.
Para
Para 26.
26. Yes, last 3 lines.
Last 3 lines. When such self-evident error comes to the notice of the court and they are not rectified in exercise of review jurisdiction, rectified in exercise or
Para 26. Okay. Okay. Page 77.
in my
Page 77.
Okay, Your Lordship. Sorry.
Okay.
Your Lordship.
When
In your-
such self-evident errors.
Yeah, to the notice of the court, and they are not rectified, just rectification in excess of review jurisdiction or jurisdiction to recall. So the judgment order, not necessarily needs to be recalled, Your Lordship. So it can be rectified by way of modification of the judgment order, Your Lordship. Now,
Yes.
Your Lordship,
You are stressing on rectified.
yes, it can be rectified. It's not necessary to recall. And Your Lordship, this Honorable Court in review petition 1 of 2021, I have furnished the judgment, the order dated 6/4/2021. Lordship,
1 minute.
order dated 6/4/2021. Pass in review petition 1 of 2021. Your Lordship has got it. Second last para. Considering the facts and circumstances under which the judgment was submission of both the learned counsel, the prayer for modification of para 18 of the judgment dated is para 18 of judgment dated by inserting such and such immediately after this is allowed. So just was modified, Your Lordship. So in
Okay, we'll look into it after receipt of your affidavit.
Lordship, but in this case, Your Lordship, if Your Lordship may kindly, come to review petition page 31.
31.
Page 30 starts from page 30, para 10 of Your Lordship judgment.
Yes.
So, and page 31, Your Lordship. May I read out the last sentence? The learned counsel appearing for the other respondent. Your Lordship has got it?
Last line.
Yes.
Para 13.
Para 10, last 3.
Para 10. Yes.
The learned counsel appearing for other respondent noted in para number 1 above, where our names are reflected, Your Lordship, have also not pointed any distinguishing feature between the two set of appointment here, except for respondent number 44 and 45, who are appointed through a regular selection process after advertisement. If this sentence is inserted, Your Lordship, it will suffice, Your Lordship.
Okay, because the error was not on the part of the court.
Lordship, error is not part of the court.
Error was
Yes.
attributed to the petitioners and all the state respondents.
On the counsel, Your Lordship. Lordship.
So let your affidavit comes.
Lordship.
On 25?
Lordship.
Same date like the other one?
My Lord.
Yes, Mr. Additional Advocate General.
Yes, my Lord. I have limited submissions to be made.
You are also filing an affidavit.
My Lord, I want to make a specific submission on behalf of respondent number 1.
Yes.
Prior to 6/6/2024, the state councils had been appearing on behalf of respondent number 1 to 5. However, by order dated 6/6/2024, learned advocate Mr. T.B. Jamir was engaged by the state respondent number 2 to 5 as their standing counsel, and learned advocate Mr. Tumbo Pongoner was also engaged by the private respondent number 6 to 45 as their respective standing counsel. Since both the learned counsels appeared for their respective respondents by filing their Vakalanama and power to appear, it was their responsibilities to file their affidavits and also to defend their cases. Even otherwise, assuming but not admitting that I receive a parawise, commands or instructions, it will be improper on the part of the respondent number 1, that is the chief secretary, to file affidavit on behalf of the respondent number 2 to 5 and respondent number 6 to 45, my lord. As the above respondents have already engaged their respective counsels to defend their cases. That, my lord, unless I receive a parawise command or instructions from respondent number 1, that is the chief secretary of the state of Nagaland, I'm not authorized to file any affidavit on behalf of other respondents. That, my lord, the affidavits filed by respondent number 20 in the review petition civil number 4 of 2024 has stated in paragraph 5 that by letter dated such and such, dated 18/4/2024, the Office of the Director General Home Guards, Civil Defense and State Disasters Response Force, Nagaland, Kohima, forwarded parawise commands, instructions to the government advocate, public prosecutor, Guwahati High Court, Kohima bench, in respect of respondent number 44 and 45, that is the private respondent number 44 and 45. However, the office of the AG, Nagaland, did not receive any such comments and parawise instructions. Even assuming but not admitting that we have received the parawise comments and instructions, the counsel for and on behalf of respondent number 2 to 5 had entered appearance on 6/6/2024 by learned advocate Mr. T.B. Jamir, who was engaged counsel in WBC 317 of 2023, Shri Kezalesa Gozu and 14 others by filing Vagalanama and power engaged by the respondent number 2 to 5, that is the Home Commissioner Nagaland, the DGP Nagaland, the Deputy Inspector General of Police Headquarters Nagaland, and the Director General Home Guards, Civil Defense and Disaster Response Force Nagaland, Kohima.
So you are reading instructions received.
Your Lordship, so I have represented only for the
Okay.
respondent number 1. That is
Now what you are reading? You are reading instructions recently received.
No, my lord. This is from the verbal instructions, which is clearly reflected, my lord, here. Therefore, after 6/6/2024, the State Council represented only for respondent number 1, that is the Chief Secretary, which is clearly reflected in the judgment and order dated 26 September 2024, passed by your lordship. That is the running page 25 of the review petition, your lordship. Therefore, my submissions may be recorded while passing the order in these review petitions. That's all, my lord.
Can you bring this by an affidavit?
Yes, my lord.
Better
I've only
file it
represented
before
respondent number
25.
1, who is the Chief Secretary.
Okay,
I
file it
told-
before 25.
Yes, my lord.
Yes, Madam Jimomi, we are fixing it on 25.
Lordship, on our part, is that I don't have anything to submit before this honorable court. It's
Okay.
that in
Let
six,
the state respondents
in
file their counter.
Lordship, actually, this 38 out of this 38 respondents have approached this honorable court in writ appeal. And it is fixed, it was supposed to be taken up day before yesterday. However, because of this review petition, it has been postponed to 13th for disposal. Because in the previous order, it has been, this honorable court observed that it should be disposed of on the next returnable date. So it was day before yesterday. However, because of pending of this review petition, it has been postponed on 13th. So, my lord, I don't know what is the what happened, but actually, when any affidavit or any other document is filed, immediately it is sent to the principal seat from the day it was filed. That is how.
Not received here. Without the affidavit, it is difficult.
Yes, that's why. So I don't know what happened, and it was filed on 5th, and why this affidavit filed by the opposite parties have not been sent to your lordship, that to the court, I don't know.
Mr. Jamir, you represent 2 to 5, right?
Lordship.
In this case, you represent
Lordship.
17 to 20.
17 to 20 in this review.
Okay. Yes, Mr. Pongener. Okay. The proceedings of this court is conducted through virtual means. First of all, Mr. Tongpok Pongener, Learned Counsel for the review petitioners. Also heard MS Jimomi, Learned Counsel for the respondent number 1 to 15. LT Sanctum, Learned Advocate, Additional Advocate General Nagaland, along with V. Jimomi, Learned Government Advocate Nagaland for the respondent number 16. And Mr. T.B. Jamir, Learned Counsel for the respondent number 17 to 20. Full stop. Mr. Jamir, Learned Counsel for the respondent number 17 to 20, has submitted that an affidavit on behalf of the said respondents has already been filed on 5/11/2024. Full stop. Para. On perusal, it is found that the said who has filed the affidavit? Mr. Jamir? Mr. Jamir, who has filed the affidavit?
I Jamir. In the name of I Jamir, Your Lordship, filed by I Jamir to be there.
Filed by I Jamir. There is an affidavit that is by
for respondent number 17 to 20.
No, pro forma respondent number 20.
Yes, for respondent number 20.
That is Autem Su.
Lordship. This is the Commandant General Home Guard.
Director General Home Guard.
Director General?
Home Guard.
Home Guard.
Commandant General. It is Commandant General Home Guard, Your Lordship.
But this is by 20.
Lordship.
But Mr. Jamir.
Because Your Lordship, respondent number 44 and 45, Your Lordship, is under Home Guard.
Is under
the Home Guard, Commandant General Home Guard. Yeah,
there is no 20. What is this? What is this? Oh, yes.
The recruitment process where these 2 review petitioners participated.
Lordship.
That was conducted by whom?
By the Commandant General Home Guard.
Commander General Home Guard.
So he has filed the affidavit.
Yes, Mr. Pongener?
Yes, your lordship, in the it was conducted by the Director General, your lordship. Director General. If your lordship may. Yes, Director General Home Guards. Page 36 of my review petition, your lordship. The advertisement.
Page 39, lordship. Advertisement is at page 39.
Then we'll take up on 19th. Right? We'll take up on 19th. Since affidavit has been received. Nobody else is filing any counter affidavit?
Lordship, on my part, I may not file.
My lord, for respondent number 1, that is the Chief Secretary of the State of Nagaland.
Yes.
No file has ever routed through the Chief Secretary of Nagaland for such appointment. So no affidavit is required to be filed.
So you been served with a copy of the affidavit filed by Mr. Jamir?
Yes, my lord.
Okay, we'll record that.
Yes, my lord.
An affidavit on behalf of the
Pro forma respondent number 20.
now he is respondent number what? On behalf of the former respondent number 20.
20 in this review.
Has been filed. Full stop. Mr. Jamir, learned counsel, who represented the respondent number 16 to 17 to 20 in the writ petition, has submitted that the respondent number 20 in the writ petition has been implemented as respondent number okay. Full stop. Mr. M.S. Zimomi, Mr. Pongener, learned counsel for the review petitioners. M.S. Zimomi, learned counsel for the respondent number 1 to 15. And Mr. L.T. Sanctum, learned additional advocate general Nagaland, appearing for the respondent number 16, have submitted that a copy of the said affidavit filed by the respondent number 2 has been served upon them, and they have gone through the contents of the said affidavit. Full stop. Right?
Yes, yes, yes.
As lays the case on 19 will do, 19.
Lordship.
19 will do.
Yes, lordship.
19/11/2024. The early order of status quo passed as regards the services of the review petitioners shall continue till the next date of listing.
Much.
Mr. Pongener, partial review, otherwise the entire judgment is to be recalled. But Jamir has submitted something.
Your lordship, in addition to that, I'll make.
Because see, for otherwise the review petition is that procedure is that if this is to be recalled, the entire judgment is to be recalled. I am asking your assistance whether partial review can be possible or not.
Your lordship, I have.
Otherwise, for the rest 43,
Yes,
illegality will be revived.
Yes, Your
Yes,
Lordship, yes, Your Lordship.
So just rectify, it is not as I have submitted, your lordship.
That is what I'll go through it.
Lordship.
But Mr. Ponjana, you please go through it and,
I would like to put in one citation which Your Lordship may also go to.
okay, give the citation.
This is 2000.
2015.
2015 to GL, 2015 to GLT SC.
Okay.
9
2015 to GLT
SC.
SC 29.
Your Lordship, yes. The fact situation is.
Review, rejected. Okay, we'll look into that.
Lordship.
Obliged.
Finding item number 5. Principals in matter.
This is the third round. Earlier, I approved the code and I want to go directly. And in the meantime, the director followed, subsequently some notices issued by them, so it again come here. And that order, first your lordship may kindly see, first order, page 24 of the report. Page 24.
I have seen.
6 and 7, my lord.
But what is interesting is page 30. An affidavit has been filed by Kala.
On the case was listed and I paid me.
From what it is there that that land is already recorded as NH road. Land acquired earlier, NH 17, old NH 37. Already acquired, there upon you have constructed.
No, we have constructed long earlier.
Whatever now, disputed questions of fact, and it is according to you, competent court.
Actually, competent court.
No liberty. What more is required?
Your lordship made an example.
Heard. Mr. A. Rashid, learned counsel for the petitioner. G. Hazarika, learned standing counsel, Revenue Department for the respond number 1. S. Borua, learned junior government advocate, Assam for the respond number 2, 3, 2 and 3. Mr. C. Borua,
4 and 5 million.
learned standing counsel,
4 and 5.
NHIDCL for the respond number 4 and 5. Full stop. Learned counsel for the parties have submitted that this is the third round of litigation. Full stop. Para. The petitioner has been projecting that he constructed structures on a plot of land having 60 feet long, having length of 60 feet, having 60 feet length and 80 feet width. Near National Highway and at a place in a village. Village?
Village.
Village. Agia, part 2, within bracket, Ulupara. Balijana Revenue Circle. District Golpara. Post stop. A process of acquisition was initiated by the respondent authorities. for the with the Ministry of Road Transport. Ministry of what does it say? Ministry of Road Transport and MOR. Highways. Government of India as the requiring authority for four-laning of National Highway number 17. 17. Full stop. When the process of acquisition was being undertaken, the petitioner approached this court by way of a writ petition, WBC number 5060/2023, with a projection that the petitioner was in occupation of a plot of land measuring 4 bighas, 2 kathas, 8 lasses, covered by dark number 363 at village Agia Part 2, Ulupara, Balijana Revenue Circle, District, Gwalpara. Full stop. During the said proceedings, no land document was produced by the petitioner to show that he was the owner of the land. Full stop. It was projected that he was in occupation of a government plot of land, and as such, he'll be entitled to compensation as a person interested. Full stop. The writ petition, WBC number 5060, 2023, came up for consideration on 1/9/2023, and the same was disposed of on the said date. Full stop. Disposed of with a direction to the respondent authorities to verify whether the land wherein the petitioner was in occupation had been included in the notification issued under Section 3A and Section 3D of the National Highways Act 1956. If the said land had been included in the notifications issued under Section 3A and Section 3D of the National Highway Act, then the respondent authorities would be at liberty to evict the petitioner from the said land. So stop. It was further observed that if the petitioner would be entitled to zero compensation, then for any structures constructed by the petitioner on the said land or standing crops, then he should be considered for compensation. Full stop. Para. Subsequently, on 22/03/2024, a notice was served upon the petitioner by the competent authority land acquisition Kala, Gwalpara. That is the respondent number 2, informing that the petitioner had constructed some unauthorized structures over the land bearing covered by DAG number 363, as mentioned herein above. Which falls within the existing right of way, right? ROW of the National Highway number 17, already acquired as per the joint survey report of the Circle Officer, Balijana Revenue Circle, dated 28/2/2024. Full stop. The petitioner was informed that as his occupation of the land, already acquired, has been was creating obstruction in the construction works of 4-laning of National Highway number 17 from Agia, Nisinta, page 28, to Paikan by the NHIDCL. And the project is a time-bound central project, he should immediately vacate. The land, or else, he would be evicted from the land forcibly, full stop. Agreed thereby, the petitioner had again approached before the court by way of another writ petition, WPC number 1858/2024. Full stop. In the said affidavit, the competent authority, land acquisition, who was implemented as the respondent number 3, filed an affidavit stating inter alia that in an inquiry conducted, it was found that the petitioner would not be entitled to any compensation. Full stop. In the inquiry, it was revealed that the structures constructed by the petitioner in the plot of land covered by DAG number 363, mentioned herein above, fell within the right of way ROW of 21 meter required for current work, was recorded already in the CETA copy as NH road, meaning thereby, land was already acquired for National Highway number 37, which was earlier National Highway number 37, 17, which was post of. When such facts were brought to light, the learned counsel for the petitioner made a submission on 6/9/2024, when the writ petition WPC number 1858/2024 was taken up for consideration, to the effect that since there were disputed questions of fact, he may be permitted to withdraw the writ petition with a liberty to approach the competent court to agitate his grievances as regards his claim for zirat compensation in connection with the aforesaid plot of land. Full stop. In view of the such submission, the writ petition WPC number so and so was closed with a liberty to the petitioner, as prayed for. Full stop. By this writ petition, the petitioner has sought to open up the litigation for the third occasion. On what ground?
Payment
Seeking inter alia direction to the respondent authorities to assess the value for zirat compensation in respect of the land covered by DAG number 363. And full stop. As it was when the writ petition was taken up for consideration, when the writ petition WPC number 1858/2024 was taken up for consideration on 6/9/2024, the learned counsel for the petitioner himself had submitted that since disputed questions of facts were involved, the petitions may be permitted to withdraw the said petition with the liberty to approach a competent court to agitate his grievances as regards the claim of zero compensation. First of it was in view of such submission, the writ petition WBC number so and so was closed with the liberty as sought for by the petitioner. First of it is thus clear that the competent court where the petitioner required to approach was no this court exercising jurisdiction under Article 226 of the Constitution of India. First of the very reason the petitioner had made the prayer to approach a competent court was due to involvement of disputed questions of fact. First of it is well settled that in a writ proceeding, disputed questions of fact which require leading of evidence by the parties cannot be is not ordinarily entered in. First of thus it is clear that the liberty granted to the petitioner who had ordered it is 6/9/2024 cannot be a writ proceeding. First of and as such, this writ petition is not to be entered in, and accordingly,
We have filed application before the authority, my lord.
we don't know.
Yes,
We are not going to enter it in. Absolutely. Then cost. Despite the order dated 6/9/2024, the writ petitioner has approached again without approaching the competent court of
No, I approve.
law. Full stop. This is an abuse of the process of the court, and as such, the petitioner is imposed with a cost of rupees 2,000, which is to be paid by the deposited by the petitioner in favor of the Guwahati High Court
Page 32, I approve.
Bar Association within a period of 2 weeks from today.
Page 32, I approve, your lord.
Deposit 2,000.
May it please, Your Lordship. Lord, this is a second round, Lord. In fact, my lord, without going to the factual controversy, if your lordship may kindly have page 219 for a moment, an extra 21.
Yes.
Lord, the order dated 29/19, this is the interim order that was passed, my lord. I may just place the first paragraph, my lord. Heard so and so, learned counsel for the petitioner, aggrieved by the letter dated 11/9/19 issued by the respondent number 2 invoking the bank guarantee furnished by the writ petitioner. The instant writ petition has been filed inter alia contending that having recovered the loan advanced to the petitioner, the respondents could not have invoked the bank guarantees in the present fashion, and therefore the ground on which the bank guarantee is sought to be invoked is nothing short of a mala fide action against the petitioner. My lord, then 221, your lordship finds the interim protection. Heard on the interim relief, considering the facts and circumstances of the case, as well as taking note of the irreparable loss and injury that the writ petitioner is likely to suffer if the interim order is declined, I hereby order that till the returnable date, the operation of the letter dated 11/9/19 shall remain suspended. So, my lord, the letter invoking the bank guarantee was suspended. Now, thereafter, at page 222, this is the last order, 29/10/24, 2023, page 223, the lordship finds, heard so and so for the petitioner and so for the counsel for the respondent number 2 and 3, submit that the present writ petition has become infructuous in view of the letter dated 13/11/2019 issued by the zonal manager NPCC Northeast Zone, which is to the following effect. Now, subject is withdrawal for claim of invocation of bank guarantee, so and so, Vidar letter dated 11/9/19, which was the impugned letter. Then at page 224, the Lordship finds, with reference to the above subject and letters referred as above, after long persuasion, the original extended bank guarantee have been received from Messrs. So-and-so by their letter number so-and-so, and the same has been confirmed for its genuinity by bank letter number so-and-so in response to our letter number so-and-so. Now we are withdrawing our invocation claim via our letter dated 11/9/19 as the original extended BG has already been received by us. Thanking you. In view of the submissions made by the counsel for the parties, the writ petition is dismissed as infraction. So the impugned demand by which the bank guarantee was sought to be invoked itself stood revoked or withdrawn. Therefore, the writ petition was closed. Now at page 225, my lord, 4 days later, this letter is issued again to the bank. Now, if I may read this, with reference to the above, it is to further intimate the termination of all projects of construction of border fencing along Indo-Bangladesh border in the state of Tripura. We have demanded so-and-so, invocation of bank guarantee number so-and-so from your end Vidar letter number so-and-so. However, the aforementioned bank guarantee was not encashed at that time from your end, citing about the stay in this regard from the Honorable Guwahati High Court, while order dated 29/19, which I just read, in the matter of WPC 7157 of 2019, filed by Messrs. So-and-so, and your bank further requested to provide any subsequent order of Honorable Court vacating the above stay in order to enable the invocation of proceeds via your letter dated 11/10/21. Now, the above writ petition has been dismissed by the Honorable Guwahati High Court via order dated 29/10/24. As the case is dismissed, and stay towards invocation of BG is also dismissed. Hence, you are once again requested to process our demand for invocation of the aforesaid BG at the earliest to avoid any litigation further. Further bank guarantee is so-and-so, the rest is not important, my lord. Now,
this is important.
My lord, the further bank guarantee is
This is the law.
This is the law. This is the law, my lord. Bank guarantee is an agreement between issuing bank and in favor of the whom it has been issued, that is so-and-so. The bank cannot deny encashment of the said BG by citing that the company is under liquidation. Recovery of the amount is an independent contract clause between the issuing bank and the BG applicant bank. It may be intimated that as per condition of the BG, you have agreed and undertaken to pay NPCC unconditionally and irrevocably, immediately on demand in writing and without protest or demur. All monies payable by the contractor to NPCC in connection with execution of works. Now, in continuation to our above, letters and correspondence with bank so-and-so by virtue of the provision of bank guarantee demand a sum of rupees 13 crores so-and-so, and invocation proceed may please be credited to our current account maintained with the State Bank of India, Beltola branch, Bukhisto, Guwahati, so-and-so. Well, this is in fact playing fraud upon the petitioner and the court, my lord. They come and represent that we are no longer interested in invoking the bank guarantee, and therefore we've issued a letter withdrawing.
What is the fraud in case of invocation of bank guarantee?
My lord,
fraud of what nature?
Egregious nature.
Is it a case of?
My lord, here, my lord, the court has been misled to believe that they have withdrawn their intention of invoking the bank guarantee.
See the content, page 224.
My lord.
They got in hand
extended bank guarantee.
Extended bank guarantee.
Correct, my lord. And then they said that therefore we are not withdrawing, we are not invoking our claim.
And that was not pressed upon. 11/9/2019. So maybe they did not come here to vacate the interim order.
My lord.
Maybe.
My lord.
In the earlier round.
But what transpires is, my lord,
that was submission. That court has interim. That was an interim order.
That was an interim order.
That is not, it has not attained finality.
Not attained finality. What I'm trying to impress on is this, my lord. They gave the impression that we are no longer interested in invoking the bank guarantee and withdrawing that impugned letter of 11/9/19. But their intention.
No, okay. Okay.
Lord, but they're into, my lord, in this fashion, my lord, today if I get a stay of this letter, they'll come and say, we'll withdraw this letter and again issue another one. It can be a never-ending process, my lord. What weighed in the mind of the Honorable Court was that the cause of action itself had died because they're no longer interested in invoking the bank guarantee, which is why it was dismissed as infructuous, my lord. Had we known that this is just a ruse to close the writ petition so that they can make a fresh demand for invocation, then we could have pressed, my lord. This is, my lord, to my mind, it appears to be a very tactful. Ultimately, my lord, the court closed the proceedings in view of the withdrawal of invocation, my lord. Little did we know that they'll again come up with a fresh demand. Now, otherwise on merits also I can satisfy, my lord.
Yes, you.
My lord. Now,
Submit on merit.
my lord, what had happened here?
Why you are settled?
My lord. My lord, this was for construction of fencing, border fencing, my lord. Now, after the project started, my lord, the NPCC realized that the sanction amount would be exponentially higher than what is actually sanctioned. And there's no quarrel with that position. And therefore, my lord, at page 185, my lord, the NPCC wrote.
Is there any contract agreement in existence?
Yes, yes. My lord, contract has been
Concluded contract is in existence.
It has been terminated, my lord, subsequently.
Terminated?
Yes.
When?
My lord, 21. 2021. Now, my lord, if I just place the background, my lord, what had actually happened was page 185 of your lordship takes.
When the interim order was passed?
My lord, the interim order was passed on 29/2019.
When it was terminated?
My lord, in 2021.
It was subsequent event.
It was subsequent.
True. Yes.
Now, my lord, what had happened was this, my lord. The NPCC realized that with the sanctioned funds, this project cannot be completed, which is why they submitted a revised proposal. That revised proposal is at page 185. My lord, I can make out a case on special equities if your lordship sees.
What special equity?
Lord, I'll just show, my lord. Now, my lord,
That you have to make out a case of that. What is that very tough word to pronounce?
No. My lord.
Very tough word to pronounce, at least for me.
My lord.
Fraud of
Aggregate
yes, nature as held by that decision.
True. My lord,
I cannot pronounce that word. You might be able to pronounce it. It is very tough for me.
Pronounce it correctly, my egregious or something.
Egregious and the decision.
Yes.
The decision which has been referred to regularly.
Yeah, my lord.
Some, not EP, some American.
Oh, Intech, my lord.
Huh?
Intech.
Huh?
Intech or something.
Not Intech. Anyway.
My lord. Now, my lord, I'll just show page 185, my lord. They said, they wrote, the NPCC wrote, my lord, that they submitted a revised preliminary estimate for amounting to rupees 150 crores for construction of so-and-so border fencing under phase 2 against the sanction amount of 50 crores. So what was initially estimated as 50 crores, then they realized that it would entail an expenditure of nearly 150 crores. Now, we were given the assurance that you please continue with the work. The moment the revision is approved and funds arrive, we'll pay your dues. That is at page 191. This was addressed to us at page 191. Lordship finds paragraph 4. The Ministry of Home Affairs has taken necessary steps for verification, scrutiny of the 4 numbers of revised estimate of eastern border of Tripura being executed by yourself from so-and-so Government of India. They've also asked for comments from CMD and PCC for further necessary action. After approval of the same by HLEC and issuance of so-and-so from CPWD FR cell, necessary step will be taken by the Ministry of Home Affairs to release the fund for 4 numbers of revised estimate. Now, at point number 7, in view of the above, you are once again requested to restart the work at the earliest to avoid contractual litigations of non-performance. So the funds had not arrived, but they gave us an assurance that revised estimates have already gone. The moment funds arrive, we'll pay your dues. Now, at page 195, annexure 7, now since the funds were not arriving, we were not receiving payments, my lord. Now it became difficult. So therefore, we wrote a letter to NP.
So against the termination, what you have done?
We've done nothing.
So just I'm asking a query.
No, no proceedings have been drawn up.
Nothing. No arbitration.
No arbitration.
No litigation.
No litigation.
Then
Then
you
one-
agreed to the termination, meaning thereby
My lord.
2021, we are in 2024.
My lord, in fact, liquidation proceedings are also on, my lord. We are though not on moratorium, my lord. These proceedings are on, so probably something will transpire to a person.
So against the termination, you are not saying that appears to be an admitted position. What is the reason for termination?
My lord, reason,
Let us see the reason.
There was a reason why this honorable court granted an interim, my lord.
No, we are not going by that. Let us see the reason.
The last annexure at page 227, my lord. They say we failed to execute the work, our progress has been slow.
So no protest
My lord, we
for last more than 3 years.
yeah, that is precise. That is in fact another ground, my lord.
No, where is the agreement?
My lord, the agreement is at page 35.
Where is the resolution? Dispute resolution.
My lord, dispute resolution, there's an arbitration clause.
Then,
My lord,
Mr. Dekka,
never the reason I'm trying to stress. Well, there was a reason why that order of 29 was passed, my lord. And
3 years have gone by since this 5/10/2021.
my lord.
On the ground that your contract agreement is terminated
My lord.
due to progress shown by you was very slow.
My lord.
Right?
My lord.
There is absolutely
Well, there's one facet of the matter.
acquiescence
My lord.
and waiver perhaps.
My lord. In fact, my lord, there's one facet which I would like your lordship's attention to be drawn to, my lord. So after this proposal for revision went, my lord, then we said we can't continue if you don't pay us our bills. Now they arrived at an arrangement that we will give you ad hoc payment since the funds have not revised funds have not come. So for now you take ad hoc payment and against that you furnish us a BG. No, so it is as good as saying my bills are already due.
Is it, then this statement is wrong.
Which one? Manu?
Tell me, this statement is wrong. That page 224. That original extended bank guarantees.
Yes, but that is.
Is it wrong? Tell me that.
It is not wrong, Manu. That is in fact a grievance, Manu. Just 2 minutes, Manu. I'll just complete. Now, Manu, 195, Manu. They said since we are not being able to give you your dues, you take a loan from us, and against that loan you advance us a bank guarantee. So it is as good as saying we will give you your own due payment, but you will take it as a loan since the revision of funds have not, the revised estimates have not been approved, and we will. Against that, you furnish us a bank guarantee. Now, we had no option.
Where is that letter?
My lord, page 196 is our request.
196,
my lord. In view of the above, we would earnestly request you to consider the following proposals in the interest of continuation as well as completion of the national importance work. To release at least 50% of the amount due against the works executed but not paid since 2009 on ad hoc basis. B, submission of bank guarantee against ad hoc payment to be made as at A above in absence of formal approval of revised estimate by the competent authority as insisted upon during discussion in a recent meeting, to release the bank guarantee so submitted as at B above after approval of the revised estimate of the competent authority. So this was the ad hoc arrangement, Manu. Now we issued the bank guarantee against this advance, Manu. Now at page 204, if your lordship takes out.
Your submission is that these bank guarantees.
Yes.
Which bank guarantees?
This instant bank guarantee was for ad hoc payments to be made to me, but since the funds
where is their reply?
My lord, reply to this is not there, but we furnish the bank guarantee in accordance with this, my lord.
But
now, my lord,
but from the contents of the letter on which the petition was rendered infructuous, it was original bank guarantees were extended.
The very
now, where is their response? Where is their response to your letter? This 196 letter.
190, in terms of 196, my lord, I started depositing BGs and they kept on insisting on.
No, what BGs? Because BG numbers are there.
Yes, BG
Let
numbers.
us see page that rendered infructuous order. Yes, BG numbers are there.
BG numbers are there.
Now they are invoking which BGs?
My lord,
Same BGs?
Same BGs, my lord.
Same BGs.
Same BGs. Now, what has happened now in the meantime, my lord? What they've done is even more. That is what my lord weighed in the mind of the court when the interim order was passed. Page 204 for a moment, my lord. So my overdue payments were given to me as a loan. Against that, they took a BG, and in my bills, they even deducted that ad hoc payment.
Original BG was for what purpose?
Original, my lord, there are other BGs, my lord. Those BGs we are not concerned with. We are concerned only with the BGs against these ad hoc advances. Page 204, my lord, for a moment.
Yes.
From my bills, my lord, they have already deducted the ad hoc advance. Ad hoc advance, 12 crores so and so, my lord. 204, my lord. Deductions, your lordship will find.
204?
Yes.
Yes.
The deductions, my lord.
Where? There are, okay, deductions.
Deductions, your lordship will find.
Up to
just
date
after
growth,
labor
bill
set,
gross.
there is ad hoc advance. So my money, they give it to me as loan, they deduct it from my bills, and then they keep on insisting on BG, extension of BG, which is why that order of interim order takes category.
You want to say that gross value of the bill?
Yes, my lord.
For the works executed up to that date
Yes,
was
my lord.
16 crore plus.
Yes.
And you have been given an advance.
Yes. And that advance was deducted.
19, how much? 19 crore.
No, my lord, 12. After labor says, your lordship will find ad hoc advance. Just after, before
12 crores.
12 crores. Now, my lord, so ad hoc, so it is something like this, my lord. Some 100 rupees is already due to me. Since I could not carry on with the work, they said you take 50 as an ad hoc advance, but against that you give me a bank guarantee. Now, my lord, while processing my bills, they have already deducted the 50. And now, therefore, in that interim order, which was passed on 29 at page 220, my lord, this was taken note of. And now, other things aside, my lord, what they did was, in my respectful submission, not fair, my lord, to say that we've already withdrawn our invocation. So therefore, you close this writ petition as infructual. And 4 days later, they say that since the writ petition has gone, the stay order will also fizzle out. And therefore, we will again raise a demand, my lord. The first paragraph, my lord, of that order at page 220, my lord, 2920.
Which one is the letter invoking bank guarantees?
My lord, first invocation is at page 218. my lord.
Against this advance, which one is the bank guarantee you have issued?
My lord, these your lordship will find at page 198 onwards. My lord.
198.
This was extended from time to time. My lord.
198.
My lord, my lord, my lord, before your lordship invests more time in this, my lord, we have unconfirmed reports that encashment has happened. My lord.
Happened?
That's what, my lord. Well, Lord will give me 3 minutes. I may have to withdraw this then.
Is it so? Yes, everything is fast generally in the
No, they don't wait.
bank guarantee arena.
In fact, we had intimated that the matter is listed today.
Okay.
Despite that, perhaps
What to do?
I'll withdraw, my lord. My lord, I'll withdraw, my lord. Will not say anything.
Okay then. If it is that fate accompli, then if it is a fate accompli invocation, then maybe. Okay, Mr. B.D. Rekha, Learned Counsel.
Or will your lordship place it on Monday? I'll just take confirmed.
Mr. B.D. Rekha, Learned Counsel. I am trying to find out something, but because of the very limited
Yes, ma'am.
sphere within which this kind of repetition is to be entertained. I am trying to find out, but not finding out anything till now. B.D. Rekha, Learned Counsel for the petition has submitted that in order to, has submitted, has sought listing of this case on Monday in order to complete his instructions. Mr. DJ Das, APS-CGC, Learned Counsel for the Learned Central Government Council is in attendance. Please the case accordingly on Monday. Monday.
I'll just confirm on them. Okay.
Item 13.
Yes, Mr. Ali.
May it please the Lord.
What has happened to Anwar Hussain?
The petitioner, my lord, applied for a building permission, my lord, for construction of RCC building, my lord. And plan has been approved. Then we have to find submit a deposit.
Individual house.
Lordship. And your lordship has already entertained, my lord.
Yes. Individual house, Mr.
Yes, Your Lordship. Yes.
Heard Mr. R. Ali, Learned Counsel for the petitioner. Mr. R. R. Gugui, Learned Standing Counsel, Environment. Environment comes earlier or forest comes earlier?
Environment Forest.
Environment and Forest Department for the response number 1, 2. 1 and 2. MSS Burua. You're for whom? Learned Junior Government Advocate Assam for the response number 3. Ms. H. Burua, Learned Counsel representing Mr. P. Nayak, Learned Standing Counsel, GMC and GMDA for the response number 4 and 5. Full stop. The petitioner has claimed that he is the owner of a plot of land, measuring 1 katha, covered by Dag number Pera to the so-and-so, Patra number so-and-so, situated village so-and-so, Beltola Moja, Dispur Revenue Circle, Kamrup Metro, subject plot. Full stop. The petitioner has further stated that he made an all-night application for building permission under the Mukhyamontri Hoj Griho Nirman Asoni by submitting all the required document, including building estimate, before the response number 4 and the response number 5. Full stop. Who accorded approval? Both.
Lordship.
Yes,
and now
the response number 4 and the response number 5, while according approval and sanction, by an impugned communication. Impugned communication where? Any date?
Lordship.
Second, 2/3/2023.
2/3/2023. Within bracket annexer.
Annexer 5.
5 has demanded payment of 2% forest royalty on the building bill or what?
The my lord royalty.
2% forest royalty.
Forest royalty. Page 17, my lord. Has been estimated, my lord.
Okay, para 2 the challenge in this rate petition under so and so is regarding committee 2/3/2023. Where is that impugn one? This
No-
was
no.
seven, annexer 4.
Page 25, my lord, the communication,
Okay.
impugn communication, page 25.
25.
Relevant, page 26, last paragraph.
Eight paragraph লিখে দিব 2/3/2023 issued by the Mines and Minerals Department so and so amending so and so. মোল্লা আছে আড়ালি লিখি দিব আড়ালি লিখিব আড়ালি লিখিব issue notice returnable so and so Gogoi Borua within 3 days interim order.
Lordship, I have an order where this writ petition is allowed, your lordship. So setting aside a 2/3/2023 order, your lordship.
Is it?
Yes. I thought that order was being placed, your lordship.
Okay. Here at 2 paragraph 2 3 লিখি দিব paragraph 2 3 Mr. Gogoi, Learned Standing Counsel, Environment and Forest Department, has drawn attention to a judgment and order dated 24/9/2024. Passed in a writ petition WBC number 4085/2024. To submit that the impugn communication date notification dated 2/3/2023 has already been set aside.
Yes, your lord. Last paragraph.
By holding that the amendments carried out by the by holding that the urban local bodies cannot impose royalty upon the private person entity in respect to private constructions carried out and consequently cannot also insist on payment of royalty as a condition for issuance of permission to construct and to carry out construction on the basis of the permission so granted. Full stop. In view of the fact that the impugned communication dated 2/3/2023 is not in force, comma, this writ petition stands allowed with a direction to the respondent number 4 and the respondent number 5 not to insist upon payment of royalty upon the petitioner as a condition for granting permission to construct or carrying out construction in the pursuant to the pursuant to approval granted already, comma, as the petitioner is constructing, is making construction in his own plot of land. Full stop. With the above observation, with the observation made and direction given above, the instant writ petition already allowed.
Item 14.
Dilwara Hussain.
May I please, lordship? Notification. Please, lordship.
Yes,
Notification dated 27/7/2024.
you are agreed by nomination of respondent number 5. Search seated person. Where is the condition that he should be clean?
Lordship, he is facing trial.
Huh?
He is facing trial and he was arrested on 14/9/2023. Page number 13, we have annexed order.
MS, there is a Assamese proverb. I think I don't know the translation. Udok Vedarokia Pata. A criminal has been asked to supervise criminals. That is what her case is, right? Heard MS
Piras.
Bidas,
Yes.
learned counsel for the petitioner. And MSS Burua learned junior government advocate Assam for the respondent number 1 to 4. Post stop. The petitioner has preferred this petition, agreed by nomination of the respondent number 5 as the chairman of Thana level Nagorik Committee of Bheluguri Police Station in violation of the notification dated 27. Where is that notification?
Page number 21.
Page number 21. In violation of a notification dated
27/7/2025.
27/7/2024. 24. Post stop. By the notification dated so and so, the composition of a Thana level Nagorik committee has been provided for. And as per the said notification, comma, where criminal record,
Bail
Order
of bail.
no, order of bail, no. Where is that one should have? Should not have criminal background. Is there anything? No.
No, Lords.
No. Okay. The respondent number 4. What is page 27?
Page 27 is impure notification.
Okay. The page 27, of course, sorry, the notification, the respondent number 5 has been appointed as the chairman by the impugn notification dated 31/8/2024, Annex RD, issue notice returnable on so and so date as MS so and so has appeared, accepted notice on so and so, extra copy within 2 days. La petitioner shall take steps for service of notice upon the respondent number 4 by registered posted AD within 2 working days. 15. 15. Not by me. This is the case before any other match video.
16.
Similar interim order has already been passed by this.
Lordship may pass over for the time being.
Pass over for the time is very hard to pass over. Okay.
Lordship may in the interim order.
Okay. Keep a copy. Who is coming? S. B and okay. Let him come. Madam, those three, where some facts are to be recorded and disposed of. Where is Mr. Gugui? Today there will be no time, but we'll make an endeavor because facts are to be recorded thereafter. This is to be disposed of, right?
They have agreed that the similar order.
Right, Mr. Biyugo should be there. Can it be some other date for disposal on a hearing date? Is there anything?
That on Tuesday.
Tuesday, okay, we'll make an effort to dispose of. Many others have already been listed. Okay. Gogo is available.
Morning he was there. Lordship.
Okay. Haveli. For the petitioner is present, is the case on Tuesday corridor. Same in 59, 60, 61. Tuesday.
62.
He has agreed, Miss Halia. Gugoi? Huh? Okay, tell him that Tuesday we'll take up for disposal. Yes.
May it please your lordship. This was a matter of service tax, my lord. Just brief fact, my lord.
Service tax.
Service tax. The petitioner had two restaurants. One is in Guwahati, near my house, my lord. And other was in Bombay. The Bombay business, my lord, he closed down in 2016.
16.
Yes,
Okay.
16 to 16.
Hmm.
And Guwahati business from 16 to run up to in 20, he closed down. Since he had business in Bombay, the Bombay GST authorities gave him notice that you have not paid the service tax. Notice. We got the receipt. Notice, we replied. Then they gave a finding. No, we have paid the service tax. In fact, I have paid the service tax, my lord. Lordship will see from entire period. From April 16 to 17 April, my lord. In the entire year, we have paid it in excess I have given. Now the Bombay authorities have given findings that we have paid inter service, so drop the proceeding. Assam authorities, what they have done, on the same fact, they gave a notice saying that you have to pay the service tax. We don't even know about this. We came from the authorities, my lord, what has been passed. We inquired in the office. In the office, we got the copy and also we got the notice. And we found, my lord, in actual lordship will page 73, that notice has been returned back to the office. It could not be served. Now, if your lordship seen their findings of these local authorities here, they have written on 3 dates they have given us for personal hearing. Dates given. And we have not appeared and they passed the order, my lord. They have not, there is no question of appearing before the. Against that, my lord, we appeared, filed an appeal before the appellate commissioner, my lord. That has been dismissed on the ground that there's no pre-deposit. Number one. Number two, pre-deposit. And number two, the ground was there's a delay. He has counted the delay from the year 2022 when the order was passed. But we received the order officially in 2024. So the 2 months. But here I have challenged, my lord, the demand notice itself as well as that appellate order, my lord. So basically my contention will be, my lord.
No, when the appealable order was passed.
Appealable order was passed, my lord. It was passed on 38/24.
38? 30.
30.
Where is that?
Page number 92.
92.
It page starts at 95 from. No, what a cover pass was it?
No, this is the Commissioner of Appeal.
Commissioner of Appeal. And
order in appeal.
Yes. And
where is the order in original?
Yes, my lord. What original lordship will find, that's in page number, my lord. Page number, my lord, yes. 70.
70.
Yes. Lordship will see the relevant paragraph 73, where I am trying to impress to opinion lordships about the notice part, page 73. Paragraph 2.1. Dates for personal hearing were fixed on 12/4/22, 7/6/22, and 12/7/22. But neither the said noticee nor any authorized person appeared for the personal hearing on any of the above 3 dates. Effort was made to contact the said noticee at his registered mobile number, but there was no response. A copy of the SCN and PS notice was also sent to their registered email address such and such. Said noticee has not been submitted any reply to the SCN. Despite granting him personal hearing on 3 occasions, he has failed to appear on any of these dates. No communication in any form has been received. This is what. Now, lordship, kindly see the notice is in page number 79. And the return, the notice I'll show, my lord. It starts in page number 79, the notice. Lordship will find the date in page number 82, bottom. In the first page, it's not there. In
Page
82. 21/10/21. Page 82, bottom in the middle. Lordship has seen that. Notice it. Kindly see the next page now. 83. This return back on the right side, my lord. It is their address. Left side is cross mark is there. It is now there. So return back to their office. It is not served on us. Now. And from that notice also kindly see what they have said. They give us 3 dates, my lord. Now they are saying they sent an email. Section 37(37)(c) of the Excise Act, my lord. Lordship has seen that, my lord, aware that they shall have to send notice by registered post or by courier service or in a it should hang in a conspicuous places, my lord. And also judgment of this honorable court, my lord. There is no provision regarding sending the notice in the email, my lord. That the judgment is there, my lord. So from their record itself, it shows, my lord. 3 dates they've given us, but the notice is written unserved. It's page number 83. How do I know?
Now the appeal was dismissed on what ground?
My lord, non-file, non-deposit of 7.5%, and my lord, it was delay on the ground of delay, my lord, limitation ground.
Where is the finding on
Page
limitation?
105. Page 105.
105.
Yes. And here is the case where, my lord, lordship will see, my lord, the entire money he had paid. I have given the receipts, my lord, in page number 32 to page number 40.
Now where is the show cause notice then?
Of show cause notice,
Show
page
cause
number
notice?
79. First show cause notice, page 79.
Do not people, do not planet. Service takes.
The source is the same from where Bombay has got the information, and these Guwahati people also got the information. Source is the same from
Now
the
where is the first one, Bombay one?
Bombay notice, my lord. Lordship will page 61. No, order is there. Lordship,
Page?
kindly see the order copy. Page 61 it starts. And
Notice,
yes, page 61 Mumbai
notice,
order.
notice, notice.
Page 55, my lord. There is a chart. The chart is also same. Amount is same. And surprisingly, both the notice are rated same, my lord. Yes.
What they say, service tax payable?
Not payable.
Hmm?
It was not paid. Now,
Which one? What they demanded there? First one.
First one, they said, my lord, service, see the chart in the bottom, first page, page 55.
Page 55.
They said service amount is shown 0. See the chart.
What they demanded?
They want that we should pay the service tax, my lord.
Service tax payable, recoverable, 96
Yes.
lakh, 96 lakh,
Yes.
so and so.
Yes. Now, please come to the findings, my lord.
No, I'll come to the finding.
Yes. And page number
Now,
56 bottom.
Rona, when you have requested to file a reply to SOCOJ.
Bottom, my lord.
SOCOJ. Now, what is the
Their reply, my lord.
order in original there?
My lord, there, my lord. Page number 62, if you lords will find.
It starts from 61.
Yes. 62 is the fact. And finding page 65. That will save your time, my lord. 65. Para 21, 1, 2, 3, 4 start. Also, would say para 22 is important, bottom. Service tax rupees 24,050, 24 lakhs 50,000 has been paid on such and such. Para 23.
Mr. Kyle,
Lordship,
page 66, para 24,
66.
para 24.
Where the above discussion, I am inclined to hold that the service tax is not liable on the notice. Registration number so and so.
And proof is in page number 32. Receipt, money receipt.
That stands paid at Assam. Earlier,
There are two units, one at Bombay and one at Guwahati.
no, yeah, that is why para 23, please.
There are 26.
Para 23,
There are 23.
last 3 lines, it is clear that they had operated the business in Assam.
Yes.
That the business in Mumbai, Thane was discontinued during the period prior to what is mentioned in the subject so-called notice.
Yes.
That has been recorded. Bombay thing is recorded.
Yes, sir.
Then stands paid in Assam. He has held that. And it is also admitted by noticee that they are to pay 41,250.
We paid them. We ourselves we said something.
That they had admitted. So now this is the where is the present so-called notice? Later one.
Page 79, my lord.
Yes, 79.
Yes.
Mr. Nath,
My lord.
why there is different service tax registration number?
Yes.
Yes. No, Mumbai is last number is 02. Assam is 01. So
No, come to page 66 again.
yes. I'm aware about
I am inclined to hold that service tax is not leviable on the noticee under said registration number. It ends with 02.
Mumbai.
02.
Mumbai. Yes. Next.
Then you have another registration number perhaps.
Yeah, kindly see that bottom.
Guwahati.
Next. Service tax and VAT or such in the shown SC instance paid in Assam except the small amount whereby they have voluntary promise. Consequently, demand raised in the shock of notice and the notice on third party such and such, my lord. Before that, my lord.
Okay, figure is same.
Para 23.
Figure is same.
Figure is same. Because
No, come to Mr. Kyle. Page 66.
Page 66.
After this 02 registration number, the service tax and VAT on the said amount of rupees 6,40,000, 65,199. Turn to page 80.
Page 80.
There is a total.
Yes, 6.
Same figure.
source is the same, my lord. Information source.
Figure is same.
But what I have seen previously, there are two registration number, one for Bombay, one for Guwahati. And lordship, the demand in the Bombay notice was different. The demand in Bombay notice was different. And in page, the page is not clear. Page.
My lord, I'm again submitting. Bombay notice was given in respect to Bombay, but when we submit the reply, my lord, they have come to the conclusion that our Guwahati business is running. Bombay was closed in 16, and we paid the money in Assam. Why Assam money should be paid in Bombay? In the business in Assam, we paid in Assam. A notice for also, my lord, kindly see.
Once again, Mr. Kyle. No, okay. No, I'm not, I'm trying to hold it. Your 02 is pertaining to
0
Mumbai.
Mumbai. One is in Guwahati, Assam.
Hmm. In this demand so called notice paragraph page 79, whether there was any mention about the earlier order?
No, because
Huh?
both the orders notice are issued on the same day actually, my lord. Same day, 21/10/21.
Huh?
Both the notice lordship will find the dates are same. 21/10/21. Mumbai also 21/10/21.
Is it so?
Yes. 79, kindly see the page number 82, bottom date.
Hmm?
Page 82, see the date, my lord.
The first one is page 55.
59, see the
Where
date.
is the date appearing?
Bottom, 59, bottom.
59 bottom.
One is 21/10/21, one is 22/10/21. Probably officer signed on that day, next day.
Hmm.
See the dates. 82, compare, now compare 82 page number. There's central authorities, my lord. There ought to have been a coordination. There's no coordination seems to be.
Yes, Mr. Khan.
Lordship,
Something is confusing.
here, they preferred appeal. In appeal, Lordship, appeal was dismissed on two counts.
Hmm.
One is there was a delay, second, pre-deposit is to be, is a mandatory. And
Okay, delay. And but question is just for a moment to be examined whether there is no liability.
My lord, please.
If it is no liability, suppose. If on examination we find that no liability, liability is there.
One page, kindly see page 32, my lord, please, my lord. Just for my sake, my lord. 30 to 40. Service tax payment. Dona Food Beverage. Dona Planet, Fort Por Assam, Guwahati, Dispur. Page 32.
What page? 32.
First line is service tax payment. Copy cyber receipt. Dona Food Beverage Limited. Dona Planet, Fort Floor, Guwahati. GS Road, ABC. I said near my house, my lord, ABC.
Well, because suppose if he has no liability, say for example, if after examination, then what pre-deposit and what delay, these will be abused now.
regarding delay, Lordship, I have nothing to say.
Delay is delay, but still,
That can be condoned, Lordship.
because of the situation here, two so-called notices,
Two so-called notice on from two authorities.
two authorities,
With respect to.
one holding that there is no liability against Bombay.
That is a final order, but the notice was issued on the same day by two authorities at Bombay and second in Guwahati, and registration number is different. And Lordship has already seen the demand is different in both the counts.
How? Page 55, come to page
Yes, Lordship.
55. 55 first.
Lordship, yes.
They have got common source, my lord. That's why the
Oh.
figure is same.
Come to page 55.
Difficulties in my repeat now.
Whereas the summary, paragraph 3, summary of the detailed comparison of the information mentioned in the foregoing paras. A comparison between the value of services provided by the SSC as per various sources. Year 2016-17, value of services provided as per RTR. 6 crore 40 lakh 65,190.
Total sale.
Total, that is value of services.
Yes.
Right.
Page 80. Compare with.
Then table, what is table 1 and table 2?
That is total sale value, my lord. 6 crores we have stated in the petition, my lord.
It is repetition or what?
The comparison of.
Anyway, then table 3. Then service tax payable. 96 lakh something. Okay. Then Focus notice page 58 as to why yearly value of services. Then service tax 9,60,000, 9,070. This is the content. Then they submitted a reply. They pay
Reply
60,
60.
6,40,665, 199. Right? Copy of service tax challans enclosed. Then order in original by Mumbai, Annexure 6, page 61, holding that it is Mumbai is closed.
Yes.
No service tax liability.
Lordship order.
And page number 60, my registration number, kindly see 000 ASD 001 is there. Registration number.
Page?
Page 60.
That
one registration number.
Now their finding is 23 and 24 order.
Mine.
Order.
I confirm the demand of service tax 41,250.
250.
Yes. That
Upon Dona.
Then
Demand of 90 so and so is dropped. I order recovery of interest 41,000 so and so.
Impose penalty.
Right.
Mine.
Para 24. Amount of rupees 6,40,065, 199. Shown in the SCN stands paid at Assam.
That's what.
Right. Now come to the impugned one notice, show cause notice.
Page 79, my lord.
Page 79. What is this? The annexes, page 70 is what?
Page 70, my lord.
This is order in original.
This is order original on the first page there.
Oh, you have annexed the order earlier than demand. Okay.
No, we have done such a way because you got the copy and then returned and then we got the, that's why it is annexed like that. First got the order copy from the office, then inquired, then we found return back. Then that's the reason we have annexed like that, serially.
Same figure, 6 crore 40. Same service tax payable. Mr. Kindly come to 80. Come to 80. Take 56 together.
80.
56 and 80.
This amount is same.
Same.
Not one paisa here and there, my lord.
Not a single rupee or paisa.
Yes.
So in such situation, you examine this because this appellate order on the ground that delay and non-deposit or pre-deposit may not hold water.
But regarding deposit, pre-deposit, there is a judgment.
You make out a case.
No, that is, I'm not going on the other aspect of the matter. With regard to the, because they preferred appeal, knowing fully well that and no application for condemnation was filed along with the appeal.
Okay, done. But if somebody is really not
liable
to pay, 1 minute, then why he should be harassed? Then the ball will be in your court.
No,
And if he fails,
yes,
then he will
I
face
agree
the
with
consequence.
Yes.
Will appeal this order.
And will accept happily.
They could have approached this honorable court before filing the appeal. When they submitted to the appellate authority, then appellate authority is bound to obey the law because apparently there is a delay. Final
Okay.
order 2022.
Okay.
Pre-deposit is mandatory.
Okay.
Lordship, I understand everything.
But if they are making a case that there is a zero liability, suppose, then let us examine it. And if they have liability,
Not on that.
I have understood your point, but otherwise, it turns out to be a clear harassment, then this amount will be imposed upon you.
No, Lordship, we are open to everything. We are open to everything.
So let us examine 56 and 80 is clear.
There is, I'm not arguing on that. My point, my simple point is this.
Highly technically is going, my lord.
Very well. Who will examine then?
No,
Who will bail the cat? The second one, second order in original, so cause notice. And resulting into an order in original. And I'll call that person then.
No, Lordship, I am open to everything.
Now we are in 226.
No, Lordship, they could have approached this honorable court earlier also, without filing appeal. And they've submitted to the appellate authority. Appeal authority has no.
No, we are not taking any.
Because being applied by the.
Government of India will not be poorer by 6,40,000. Heard, Mr. am not. Government of India is not going to be poorer. We'll examine the issue. We'll examine the issue.
Normally he's large-hearted, my lord. Today I don't know. Normally he's large-hearted.
Mr. M. Nathan, senior counsel, assisted by Mr. D.P. Boral and counsel for the petitioner, and Mr. Sikal and standing counsel GST for all the respondents. The petitioner operated. Now you're closed down.
No.
Both
Don't close my.
operated. Two restaurants, that's one in Mumbai and one in Guwahati. And for running the said business, the petitioner had service tax registration number PS 56 lamba hoy de. PS 56 AAD CD 1411 ASD 001
What is registration this?
for Guwahati.
Yes, ma'am.
And eke hobo 01, right? Same, only one is different.
Yes, ma'am.
For Mumbai post office. The petitioner was served a demand comes show cause, a notice to show cause and demand
It was not served, my lord, actually, no.
was issued.
Mumbai was served.
I am on page 55.
So,
The petitioner was served with a notice to show cause and demand by the Joint Commissioner CGST Mumbai West dated 21/10/2021. Under section 73 or what? 73. 73 or what? 70.
Finance Act 1994. 73, Finance Act 1994.
Section 73 of the Finance Act,
Finance Act.
1994, showing the following liability. Page 56, table 3, table 3 here. The petitioner responded to the said notice of demand, so cause come demand, by filing a reply on 9/11/2021. Full stop. Subsequently, the said authority that is the Joint Commissioner CGST Mumbai West passed an order in original dated 25/8/2022. Holding inter alia that the business in Mumbai Thane was discontinued during the period prior to what was mentioned in the subject show cause notice, and the petitioner was operating a business, the business in Assam. Full stop. It has been held that service tax would not be leviable on the notice and the registration number 02, ending with 02. Post of, as the petitioner itself had admitted that they would be required to pay an amount of rupees, a sum of rupees 41,250 towards service tax after making payment of rupees 6,40,065, 6,40,000, sorry, 6 crore. Service tax, after paying service tax on the amount of rupees 6 crore 40,65,199. Correct? So accordingly, comma, by the said order in original, comma, he ordered recovery of rupees 41,250 while dropping the demand of rupees 95. Dropping the demand to the extent of rupees 95,68,530 within bracket equal sign rupees 96,09,780 minus 41,250. Full stop. Close on the heels of the previously mentioned demand comes show cause notice, demand comes show cause notice of the Joint Commissioner, CGST, Mumbai.
Yes, ma'am.
Mumbai West, comma, another demand comes show cause notice dated 21/10/2021
21.
by the Additional Commissioner, GST,
Yes.
was purportedly issued to the petitioner for the following. Page 80, table. Para. The show cause notice, demand comes show cause notice dated 21/10/2021 of the Additional Commissioner, GST, Guwahati,
Yes.
resulted into an order in original dated 38/2000, sorry, not 38. What is the date?
That is my lord.
12/7/2022.
12/7/2022.
Please
Holding the petitioner liable to pay service tax. Full stop. The subsequently, comma, when an appeal was preferred, comma, the appellate authority rejected the appeal by an order in appeal dated
38/24.
38/24
Page 92.
on the grounds of non-deposit of
7.5% pre-deposit. Page 105.
non-deposit of pre-deposit due to failure on the part of the petitioner to make pre-deposit and on the ground of limitation. Full stop. Para, it is the contention of the petitioner that for the said amount, comma, after proceeding initiated by the Joint Commissioner, CGST so-and-so, West Mumbai, finality, it could not have, the respondent authorities could not have proceeded with the subsequent proceeding in the same facts and circumstances, right? Full stop. The matter would require further consideration. Issue notice so-and-so.
My lord, one sentence, I think. That notice in page 83, Roshil File is returned back to their own office in Guwahati.
Yeah, we are on only issuing notice.
Now, one sentence.
We are not.
What was my lord? When the court changes, my lord. One sentence, my lord. Will.
Extra copies we need to work in this. having regard to the proceedings initiated by the demand comes show cause notice. Annex 4 and the demand comes show cause notice Annex 9, comma, the petitioner has been able to make out a privacy case for interim reliefs accordingly, comma, the operation of the order in appeal dated so and so shall be kept in abeyance till the returnable date. Issue notice returnable.
1312. Much up now. Item 63. My lord, if your lordships like said, state that appellate order, then if it comes back, this one revives. That appellate adjudicating officer, first order in original.
Okay, order in original dated so and so, annex so and so, and order in appeal so and so.
12/7/22. My lord. 63.
What? Delimitation.
Yes.
We are putting it every Monday. Hello. We like to hear other things. What is your basic ground?
My lord, basic ground is, my lord, under Article 243, Section 3 and Section 5 non-violation, and my lord, SOP violation, subclause 6 and 10 of subclause 4, and ECI guidelines and methodology in delimiting, my lord. And the violation of the guidelines of Election Commission of India, where the guidelines and methodology of delimitation is elaborately given, my lord, and all are violated, my lord. Almost many factors are violated.
Who are you otherwise?
My lord, yes, my lord. I am the president and secretary of an NGO, my lord, from the village, my lord, and we have the entire village.
Apart from all these constitutional provisions,
yes, my lord,
and the statutory provisions,
my lord,
in the Assam Panchayat Act,
yes,
factually what you have
my lord
contended.
Yes, my lord. My lord,
Any with facts and figures.
Yes, my lord. At the beginning, my lord, I must admit, my lord, the contention I have raised, all the supporting documents are still not available. Some are available, but some are not yet.
No, writ petition is not EMI.
No, my lord. What happened, my lord?
I'll not consider EMI.
Even, my lord, some documents still not available except.
No, what factual?
Yes, my lord. I'm coming to the only one example, my lord.
Take me to the writ petition.
Yes, my lord. Kindly, my lord, kindly see one sketch map I have annexed, my lord.
No, sketch map will not do what is pleaded.
Yes.
Factual.
First of all, my lord, there are 20 ZPC constituencies, my lord. Kindly turn to page ZPC constituencies, my lord. At page, my lord, 58, my lord, of the SOP.
I'm asking you because what you have pleaded.
My lord.
What is pleaded? Please take me to the pleading.
Yes. My lord, paragraph 2 of my petition, my lord.
Paragraph 2.
Yes, my lord. Page 8, my lord.
Okay.
That the petitioner filed this petition challenging the impugn final delimitation of Kapanchayat constituencies under Karimganj district, published on 15/10/24, whereby the total number of Jilla Parishad has been reduced from 20 to 16, delimiting many Gaon Panchayats very illegally, irrationally, in gross violation of Article 243 of the Constitution of India.
Show me, take me 20 to 16. Where?
Yes, my lord.
Show me.
My lord, page 58, my lord.
58.
My lord, at serial number 18, my lord. there is serial is 20, my lord. But now, my lord,
No, you are from which place?
I am from, my lord, Karimganj district and from Concolors, ZPC, my lord, and from earlier Lamajar.
Karimganj. You are
Yes,
from Karimganj?
Karimganj, my lord.
Okay, Karimganj.
And
Karimganj.
Concolors, ZPC, my lord.
ZPC is 20.
ZPC.
20?
Yes.
20?
20.
Huh.
Now, my lord, kindly turn to page 63, my lord. This is the abstract of delimitation, my lord, proposed delimitation. In short, my lord, just given, my lord. Kindly see the below last at the right hand side, my lord, number of ZPC proposed is 16 in total, my lord. 16 in total from 20, my lord. And my lord, names or details are annexed in the my lord, the final list, my lord. Details is there, my lord. There are 16 as of now, my lord, out of 20, my lord. No, my lord. Similarly, my lord, kindly many GPs, my lord. In many GPs, my lord, one part of GP from excluded, my lord. One part or one ward or one GP or part of one, my lord, revenue village is excluded from one panchayat to another and tagged with another panchayat included, my lord, by crossing some villages, by crossing some other Gau panchayats, my lord, having no reason, no logic, nothing, my lord. Only for reasons best known to them.
Factual, what are the exact thing where it has happened?
Yes, my lord.
What is pleaded in the statement?
Yes,
I'm not
yes,
having AI
my lord,
that scan through
my
and
lord,
analyze.
then comes
Please.
the page 2, my lord.
Paragraph 2.
Yes, my lord. Article 240 of India's guidelines methodology of the Election Commission of India. Coming to know about the many utterly illegal and irrational proposed delimitation, more particularly the bifurcation and exclusion of revenue village, Mirzapur Part 2, Dakshinkul Part, Ward number 7 of Lamajor Gau Panchayat, from Lamajor Gau Panchayat and inclusion of the same village within Mohakol Gau Panchayat, crossing over 3 other Gau Panchayat areas in between, situated at a distance of 8 kilometers, with 2 changes of bus or auto to reach there. This petitioner village council had immediately hold a general meeting on so and so, my lord.
So this Mr. Doctor, this is one allegation.
My lord, an example, my lord, kindly turn to the page, my lord.
I'll not go to the annexers. What is pleaded here,
yes,
I'll look into it.
Yes.
Out of annexer, many things can be said. What is pleaded is to be considered.
The next paragraph 3, my lord, that the petitioner states that under the provisions of Part 9 of the Constitution of India, the Assam Panchayat Act 94.
Okay, those, I'm not saying that 243C and Section 5, you do not have to mention.
Yes.
Okay. Any factual one. Any factual thing otherwise. And then SOP all are.
My lord,
okay.
Yes, my lord.
Category A, category B, category C, okay.
Yes, categories not
okay,
yes,
okay,
none.
it is okay.
Now, my lord.
Now, factual thing what?
Factual thing, my lord.
Everybody will say fundamental violation, everything,
Yes,
everything, you know,
yes,
blah, blah,
yes.
blah, blah, blah.
Yes.
But what is material in this petition is paragraph 2.
My lord, yes, my lord.
Apart from all these constitutional principle violation, statutory violation, SOP violation, election commission violation,
yes.
Otherwise the factual
yes.
backdrop is paragraph 2.
Yes, my lord. And one example I have annexed through my map, my lord, how it is happened, my lord.
It is there, bifurcation, exclusion of revenue village Mirzapur
Part 2
of the Lamjuar from Lamajor
to Mohakal.
That's all, Mahakal.
My lord, kindly, my lord, see what happened. Kindly, for
No,
one
what is
minute,
pleaded, I'll only see.
my lord, kindly see one thing, in this map, my lord. The Panchayat office is adjacent, contiguous to the village, my lord.
I am taking it as true. Your
Yes,
statement in
yes,
paragraph
yes.
2, that is why I have asked
Yes.
him to note down.
Yes.
Okay, take it all there. Yes, doctor, release the case on Monday.
My lord, I may be allowed to file some additional document, my lord.
No installment. I am not issuing notice, not giving, granting.
My lord,
anybody.
My lord, what happened?
Not granting anybody anything.
Production list,
Okay.
item number 1.
May I please, your lordship? Lordship, sir, I'm seeking a mandamus, lordship. Lordship, what had happened is that the Sonapur Gao Panchayat, they had a building.
Mandamus is very dangerous.
Yes, lordship,
I flipped through, I haven't seen page 11. But mandamus to renew the tenancy, this kind of mandamus is not possible.
Lordship, what I am seeking right now, lordship, what had happened is that the Sonapur Gao Panchayat had a building where second and third floor was constructed, and they said that it will be a Viva Bhavan. Once it was decided in the Gao Panchayat that it will be given to unemployed youths, but the youths did not take it. Then it was decided to give it to rent to the petitioner for 25 years, renewable at 11. After
25 years. At what rent?
It will be increased. That portion is there.
Negative mandamus will be issued then.
Lordship, the point is that right now, what had happened is that after the agreement was there, then we did some renovation.
At the time of mention, you were saying something.
Yes.
What is that?
Yes, what had happened is that now on 25th August to 24, this agreement, 11 months was over. So I approached for renewal.
So you have taken the booking for some day?
Yes.
11 marriage.
11th and 15th is there. So
therefore, let him.
So what I pray,
since he has taken the money, don't take anything.
So, Lordship,
let that marriage be held.
What I pray is it can be disposed of, saying I have given a representation. Let them consider whether they renew me or whatever be it. And till the disposal, the agreement subsists.
Oh, that I will not say.
Or at least
I'll say that allow him to conduct at least.
At least the marriage.
Page 47.
Huh?
Governments actually.
You take instruction. In the meantime, I'll say that let him hold the marriage. I think that will do. You have taken the money already. Heard Mr. R.J. Das, learned counsel for the petitioner, and Mr. S. Dotto, learned standing counsel, Panchayat and Rural Development Department, for all the respondents. First, the petitioner has stated that the petitioner has entered into an agreement with the respondent Hunapur Gao Panchayat to a commercial premise measuring 4,200 square feet situated at Sunapur to establish a marriage to operate a marriage stroke banquet hall by the name and style of Riverview Viva Bhavan, and accordingly, monthly rental was agreed upon.
Yearly rental. Yearly.
Yearly rental was agreed upon by execution of a tenancy agreement dated
25 August 2023.
August 2023. Full stop. After execution of the tenancy agreement, the petitioner has been running the marriage stroke banquet hall. Full stop. Petitioner has further submitted that somebody writing, Panchayat and Rural Development Department writing these letters.
Yes, Lordship. They in fact
has submitted that the Panchayat and Rural Development Department by the Government of Assam by the communication dated 10/9/2024 wrote to the Chief Executive Officer, Kamrup Metro Jilla Parishad, who, in turn, wrote to the so-and-so on 10/9 question. 10-9 কৈছো, 2024. And the Chief Executive Officer, Kamrup Metro Jilla Parishad, had in turn wrote to the Block Development Officer, Dimoria Development Block, Sonapur, and Secretary, Sonapur Gaon Panchayat, to assess the market value
Yes, sir.
of the concerned marriage stroke banquet hall, purportedly on the ground that the present lease period had expired. First of all, it is the case of the petitioner that for the purpose of holding a marriage on
Lordship, it is 11, on 11 it is there, on 15 also it is there.
okay, on 11/11/2024, and
15 is also there.
two
15.
marriage ceremonies.
In fact, Lordship, on 25 is also there. There are,
One by one he's extending.
No, 25 and
Okay, today is what? Today, Adjudication?
Today is my lord.
Today is
8/11.
Okay. To hold 3 marriage ceremonies on 11/11/2024, 15/11/2024, and
25/11/2024.
25/11/2024, the marriage, the concerned parties have already booked the marriage banquet hall, and the petitioner has already received the advance amounts. Full stop. In the petitioner is apprehending that the respondent authorities might undertake coercive action to evict the petitioner from the marriage banquet hall, which the petitioner has taken pursuant to a tenancy agreement. Full stop. The matter would require further consideration. Mr. Datta, learned standing counsel, Panchayat and so has submitted that it is the tenancy agreement is only an authorized agreement.
Well, without issuing an item.
And without issuance of any NOC. NIT, okay. First of all, the matter would require further consideration, issue notice returnable on.
After 25, my lord.
After 25, let him run.
Yes.
4th of December. As the petitioner has said that, has averred that three marriage ceremonies on so and so date as for holding three marriage ceremonies on so and so date, the marriage banquet hall has already been booked, and the petitioner has received advance amounts for that. It is provided in the interim that till the returnable date, the respondent authorities shall not take any coercive steps for the purpose of evicting the petitioner from coercive steps. Shall not take any coercive steps for the purpose of evicting the petitioner from the marriage banquet hall, and the petitioner shall be allowed to allowed to permit.
Already booked.
Permit. Don't take many other. Allowed to petitioner shall allowed to permit. Petition is permitted. Petition should be permitted to operate the so and so hall till the returnable date.
On that day, whatever bring.
My lord, no more further bookings, my lord.
Lordship.
Otherwise, next day he will say, my lord.
No, thereafter we'll see.
My lord, for one, just for one knowledge, my lord. Lordship may kindly come to page number 23. Once, my lord. This is the page of the agreement. Page number 2, my lord. Second last paragraph. Yearly 60,000. Now Lordship may kindly come to page number 43.
For one marriage, they are charging 74,000. And for the whole year, they are paying only 60,000.
But
Okay, if,
that includes
Uh,
the other things are there. It's not about the.
it is made clear that if the any dues are payable as the in terms of the tenancy agreement by the petitioner to the respondent panchayat authorities, then the same shall be cleared by the petitioner.
It's already clear. Deeply. Otherwise,
Whatever dues is their pay.
it's already. It's all.
Item 2, production list.
Are was any? You too? Okay.
May it please, my lord. My lord, the respondent authorities, they've gone. My lord, they've submitted one notice, my lord. May I kindly submit it before this honorable court? No, two change, two. Ma'am.
Oh, yeah.
Notice the My lord, this notice says that they'll have given us time till 4 days, my lord. After 4 days, they'll come back, my lord. My lord, in the said notice, if my lord
26.
my lord may kindly have the National Highway Act, my lord, for a moment.
During the periodical inspection of the soils of Pythons, it is observed that numerous enterprises taking place at soils of the soils. Therefore, through this office, there is to remove
Notice this side.
such unauthorized national highway right of way
4 days.
4 days from the date on which the notice is served with new. Comply with this notice of render the license your post and yes, when this notice was issued.
My lord, today afternoon we got this, my lord. My lord, may I kindly submit one thing? My lord, may kindly have the National Highway Act for a moment and the Control of National Highways Land and Traffic Act 2002 for a moment, my lord. Would like to point out certain important points, my lord, regarding the said notice, which has been issued under section 26(2) of the said act. My lord would kindly have section 14 of the said act, my lord, the Control of National Highways Land and Traffic Act 2002 for a moment, which postulates that as per this section, my lord, we can prefer an appeal under the section 26, my lord, which has been issued to us regarding illegal occupants. My lord, section 14, my lord, has appeals, my lord. May I kindly read, my lord? An appeal from any order passed or any action taken, excluding issuance or serving of notice under sections 26, 27, 28, 36, 37, 38 by the highway administration or an officer authorized on its behalf, as the case may be, shall lie to the court. Now, my lord, this court is the civil court. My lord would kindly have the definitions, my lord. Definition part, court, my lord, DA. If I may read, my lord, court means the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction. Thereafter, my lord, section 19, if my lord has for a moment, of the said act, which talks about limitation, my lord. Every appeal to the court under this act shall be preferred within a period of 60 days, 60, from the date on which the order appeal against has been made. Now, my lord, this section we have got, this notice we have got under 26(2) of the said act. As per that, my lord, as what the respondent authorities have given us. Now, my lord, as per that, we have this 60 days period to prefer the appeal. So there is an alternate remedy available.
But I have read the section 14 differently. An appeal from any order passed.
Yes.
or any action taken,
Yes.
excluding issuance or service of notices, comma, under section 26. Now let us read 26.
My lord. May I read, my lord? Removal of unauthorized occupation. Where the highway administration or the officer authorized by such administration in this behalf is of the opinion that it is necessary in the interest of traffic safety or convenience to cancel any permit issued under subsection 2 of section 24, it may, after recording the reasons in writing.
That is not attracted here, rule 2.
Yes, my lord, I will come to that, my lord. When, comma, as a result of the periodical inspection of highway land or otherwise, the highway administration or the officer authorized by such administration in this behalf is satisfied that any unauthorized occupation has taken place on highway land, the highway administration or the officer so authorized shall serve a notice in a prescribed form on the person causing or responsible for such unauthorized occupation, requiring him to remove such unauthorized occupation and to restore such highway land in its original condition, as before the unauthorized occupation within the period specified in the notice. Yes, my lord. Under 26(2), my lord, they have served the notice, my lord, today.
Then,
my lord, what
notice is to do what?
notice?
What right notice he has?
My lord, to
Under a provision?
my lord, as per 26(2).
Notice under so and so has been made.
Yes.
Then read 6. Sub-rule 6.
26(6). Where the service of notice under subsection 2 has been made under subsection 4 or subsection 5, and the unauthorized occupation on the highway land in respect of such notice is served has not been removed within the time specified in the notice for such purpose, and no reasonable cause has been shown before the highway administration or the officer authorized by such administration in this behalf for not so removing the unauthorized occupation, the highway administration or such officer, as the case may be, shall cause such unauthorized occupation to be removed at the expense of the central government or the state government, as the case may be, and impose penalty on the person to whom the notice
Now
is addressed.
come to page 68.
68, my lord.
Your read petition.
My lord. Yes, my lord.
Now, if you read the third line, ROW, right of way,
Yes, ma'am.
that has already been crystallized in favor of NHIDCL. And it is suggestive of the fact that the stage of 3A, 3D, all these have been crossed. Lane vested in the central government, absolutely. Right. So it is right of way created. Now it is unauthorized. It has become unauthorized occupation. Now still you are having time to vacate.
My lord, I request.
We don't find any case for interim order.
My lord, at least till Monday, my lord, Monday.
That is there. 4 days.
They could not evict the people, lordship, because they have demonstration, this protest in that place, lordship. So tomorrow is Saturday, day after tomorrow is Sunday. So they think
4 days, I think, given. How much time is entitled under rule
My lord, rule
2?
so lordship, already notices have been given, they have
my lord,
given
rule
reply.
2 of the traffic act.
Sub-rule 2. Madam Bora.
Definitely. I will from here, sir. Awesome.
Traffic act. Yes.
Oh, yeah, that's it. No, no, no. Definitely, no, it is.
You make a representation
Yes,
on Monday
yes,
to this authority?
my lord.
Yes. Lordship, actually, the color with the, in the notice itself, the,
But this is not part of the,
My lord, we got it at 1:30 PM today. During lunchtime.
because they could not go ahead with the eviction matter procedure, Lordship.
but
so-
Madam Bora, there is a provision for representation and hearing also in under Rule 26. If you read sub Rule 3. Heard, Mr.
PR Sharma.
P.R. Sharma, learned counsel for the petition. Petitioners and Ms. R.B. Bora. R. Bora, learned standing counsel. NHIDCL, for the respondent number 1, 2, and 3. G. Hazurika, Revenue Disaster Management Department. 4. S. Borua, Junior Government Advocate Assam, for the respondent number 4, 5, 6, and 7, full stop. The petitioners, 11 in number, have projected that they are in possession of government khas land, the khas land,
Government land, Lordship.
different parcels of land covered by Doc number 145, 203, and 369, at Tarapur, village Tarapur, Dudnoi Revenue Circle, District Gwalpara. Since about 20 to 30 years and have constructed structures thereon in order to earn their livelihoods. Post of a process of acquisition, land acquisition under the provisions of the National Highways Act 1956 has been undertaken, and in the process during the course of during the process of acquisition, notifications under section was undertaken for the purpose of a project named quote unquote 4-laning from Paikan to Dhupdhora unquote in district Gwalpara. Full stop. The additional deputy commissioner Gwalpara is the competent authority land acquisition Kala under section 3 small a of the NH Act 1956. Full stop. From what transfers from a letter dated 5/11/2024 within bracket Annexa 5, written to the additional deputy commissioner Gwalpara and the circle officer Dudnoi Revenue Circle Gwalpara that notices had been served to the awardees stroke interested persons and processors, and certain portion of compensation for Jirat, structures had been paid. But it has been reported by the acquiring authority Messrs. NHIDCL that there has been hindrance within the right of way, and the same has caused delay in construction works of the highway. Post op. The said authorities have been requested for clearing the acquired lands. We have already received notices and to evict the structures within the right of way in coordination with the Superintendent of Police Kualpara and the General Manager and the concerned NHIDCL authorities, ensuring photographic and videographic evidence regarding the eviction drive. Full stop. Yes, you are issued notices for vacation.
And then them have all awardees, they have the issue notice.
Mr. Sharma, Council Board of Petitioners
23 also, he has written a letter.
has submitted that today the petitioners, some of the petitioners were served, have been served with a notice and subsection 2 of section 26 of the Control of National Highways within bracket Land and Traffic Act 2002, providing them 4 days to remove the structures which they claim to be unauthorized in the right of way of the national highway. Post of Para Ms. Bora, Standing Council, NHIDCL has submitted that from the letter dated 5/11/2024, it is evident that the the land has been acquired after due issuance of notifications under section 3A, section 3D, and 3,
G.
not G, I don't know.
Compensation, the award is also.
It is not sure.
Because here it is mentioned that notices were served to the awardees.
And 3D, 3D of the NH Act 1956. And as such, the acquired land is has vested absolutely in the central government, free from all encumbrances. And as a result, the right of way belongs to the respondent authorities, more particularly the acquiring authorities, more particularly the central government. First of, as per the provisions contained in section 3E of the NH Act, where any land is vested has vested in the central government under section 3D, have you been paid? Huh?
Not paid.
The petitioner, petitioner should hand over should vacate from the place by removing the structures. First of, it has been, MS Bora has drawn attention to the application submitted by the petitioners and the contents of the petition to submit that the structures of the petitioners have already been marked during the survey conducted by the acquiring authority. First of, NHIDCL to requiring authority, NHIDCL to us. Issue notice returnable in so and so. As so and so has appeared, accepted notice on behalf of the so and so. Mr. Sharma, Learned Counsel for the petitioner, has prayed for an interim relief. Full stop. Having regard to the fact that the stage of the proceedings under section 3A and section 3D are already over, and the land has vested absolutely in the central government in view of the provisions contained in subsection 2 of section 3D of the NH Act, this court is not persuaded to pass any order stalling the process initiated by the respondent authorities, full stop. If the petitioners have been served with notices under subsection 2 of section 26 of the Control of National Highways within bracket Land and Traffic Act 2002, the petitioners are at liberty to approach the appropriate respondent authorities in terms of the provisions contained in section 26 of the Act by submitting representations.
Pilot till then status quo.
Already 4 days given, Mr. I have seen it. 4 days given up to 12. You are not going to be evicted. Submit it on Monday. Then content what is there in the provision.
Monday, let's see, you can go ahead with eviction.
Okay, as contained by so and so, the petitioners are at liberty to so and so within the period of 4 days mentioned in the said notice as contained by Mr. Sharma. 4 days. So it is.
My lord, may I kindly seek a clarification? My lord? Who will be the respondent authority to whom I have to prefer the representation?
Read the Act. Read the Act.
My lord, pending disposal of the representation.
Huh?
Pending disposal.
You are at liberty there. You urge all these grounds there. Otherwise, 3D stage is over. It is now central government. Everything belongs, nothing belongs to you. Even the structures.
Obliged.
Obliged. What is this?
So far, my lord, the grievance of the petitioner is concerned.
I've been told it was not mentioned before me.
Yes, yes.
Huh?
I actually on wrong, my lord, impression that it is a matter of pertaining to bench 4, my lord. That is why, my lord, it was mentioned.
I have not permitted anything.
Yes, my lord. So far, my lord, on wrong impression, my
Now,
lord.
how can it be listed without my permission in an unlisted matter?
My lord, it was permitted by the learned Honorable Justice Michael.
How can it be?
Because
Then I will allow permission unlisted everywhere except me.
No, my lord,
How can it be?
I was told.
Mr. Sharma, I'll at 10:30, I'll permit 20 unlisted motions
No, I'm sorry, my lord.
for other benches. For other benches, right? List, I'll permit everything.
It was, my lord, on wrong impression that it is a matter pertaining to bench 4, my lord. That is why, my lord.
Now at 4:30, how can I take?
Up to lordship, my lord, because my guess.
No, this is not the way.
I could understand. I could understand.
And the other court cannot permit
Yes, yes.
to list a unlisted motion in another
I
court.
have wrongly mentioned, my lord. That is why permitted.
Then how again it has been listed?
It is up to lordship.
The motion I have permitted, I have taken up.
My lord, so far, my lord.
Because my court master has seen the mention memo.
Yes, yes, yes. I admit, my lord. I admit, my lord. So far, this part is concerned, I have committed wrong, my lord. So far, mentioned.
List on Monday.
My lord, may I submit, my lord?
List on Monday.
Sports is going to be scheduled on, my lord, on 10th, my lord.
No, in a manner which is not permitted, I am not going to do. Whatever is going to happen, it will happen.
Let it be on Monday.
Monday. I cannot take up.
My lord, I'm sorry.
Whatever I have permitted, I have taken up.
I could understand.
Beyond time. Whoever has. Yes, anything, Mr. Because of some cases have beaten up. This is motion. Motion. Which one? 16.
I think so. Time.
16.
I take your apology.
Oh, timing. Oh, you are not there.
Went to NCLT for
Oh, you have gone to NCLT.
for timing.
Similar order which was.
Yes. What do you say about this?
You have already given.
One state, 10 central. So
Okay, MS Havelia, you do the correction, whatever correction by pencil. Yes, Mr.
she has put one WPC 680/2024 on this matter. My lordship own judgment. 12/2024.
It is only order, interim order.
That is right now I have to say. Otherwise, I leave it to the court.
Do the date correction here. With what is to be written, MS Havelia? Issued a demand notice under section 73 of the SGST Act on what date?
Under the SGST Act, Lordship, there are 3 orders, so I will have to give 3 orders now.
Do the
3
correction.
orders.
Dr. Goy, please check it. Is any other thing important issue which is to be taken up or to be listed some other day? Yes, Mr.
Sorry that I am mentioning, my lord, one matter item 47.
47.
There was an interim order on 25/9/24
Injunction 47 too.
till today.
Okay, 47. Case to deal. Affidavit filed?
No, ma'am.
Okay. Heard Mr. P.K. Roychuri, Land Council, but a petition. A response by the counterfeiters by the respondent authorities are not yet filed. First of release the case after 3 weeks. The interim order passed earlier shall continue till the next list.
Item number 26, my lord. Can we fix on next week, my lord?
26. What is the case about?
Case is about land acquisition, my lord. There's a compensation amount that has been stayed, my lord. I'm for the school, man. Respond number 7.
No, next week is not possible. Someday else, Mr. Counsel.
Date may be fixed, my lord.
Okay, that Mr. Hari, hello, Mr. Who is there? You are for the petitioner?
For the respondent number 7.
Mr.
S. Kakoti.
Kakoti Learned Counsel for the respondent number 7 is present. Full stop. As sought for by him, list the case. He has sought listing of the case after 2 weeks. List the case on swings.
In item 57, I have to take Dusty service. 57. I have taken, but due to vacation, I could not able to serve. It is on record. So only a date, any date may be fixed so that I can take fresh on respondent number 4.
Okay, list the case on swings so that. Yes. Any interim order to be
Interim order.
extended? Where?
Item number 31.
31.
And Lordship, we want to file a reply affidavit in this matter.
Mr.
R. Duara.
R.
R. Duara.
Duara, Learned Counsel for the
Petitioner.
petitioner has prayed for and is granted. How much time?
3 weeks time. 3 weeks.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the
Respondent number 2.
respondent number 2. Full stop. Lays the case after 3 weeks. The interim order passed earlier shall continue till the next date of listing. Any interim order? Any interim order? No. Leftover. It will be listed.
Item 29, there is an interim order. Interim will be
29. Okay. 29 to Dixon. Mr.
BP Sharma, Lordship.
BP Sharma, Learned Counsel for the petition is present. Due to paucity of time, the matter could not be taken up today. Raise the case after 2 weeks. The interim order passed earlier shall continue till that.
Well, item 22. Item 22.
Interim order. Robin Chandra Day.
Yes, sir.
There is no interim order.
Its status is there.
If it is there, there are no interim order, not, nowhere.
Yes.
Which order?
In 17 is, since 17 is running.
Huh?
Yes, Your Honor.
Which order? Where is it?
15 to 17 order.
15 to 17.
Yes, Your Honor. Initial order.
Why you are asking for extension? Huh? 22nd March 2027. Interim order passed shall continue until further orders. So why you are wasting time?
Item 20, my lord, it's became infractious.
20. What?
Infractious.
20. It is connected with some other cases?
Yes, all, actually, all has been infractious, my lord.
You are the counsel or what?
No, only 20, in 20 I am the person.
Okay, 20. No, 20. Mr. S.K. Roy, learned counsel for the petitioner. Petitioner has submitted that the subject matter of the writ petition has become infractious. What kind of challenge was made?
Actually, the managing committee of the.
Oh, expired already. In view of the above submission made by Mr. Roy, the writ petition stands dismissed as having rendered infractious, stands closed. 17, 18, 19, এটা list the cases, বেলেগকে লিখি দিব, বেলেগ কিবা এটা date দি দিব.
My lord, in item
Yes.
of item number 10, we are in the impression that it was fixed on 13th, that is Wednesday, but it was fixed on 20th. We need the matter on 13th, my lord. Item number 10, my lord. 20. But it was on Wednesday. We are in the impression of next Wednesday. Of course,
আৰু কি আছিল next Wednesday?
income tax matter, my lord.
Okay, wait. Where is 13?
Hurry up.
Item number 24, kindly allow us to file additional affidavit. Lordship.
Miss
M. Pal.
M.
Pal.
Paul, learned counsel for the petition has prayed for and is granted 2 weeks' time to file an additional affidavit on behalf of the petition. Additional affidavit. Lays the case after 2 weeks.